Good evening and welcome to the November 29th, 2023 meeting of the Town of Gray's Zoning Board of Appeals. Our first item is roll call. Derek Shirley.
Here.
Anthony Grabars.
Present.
Georgia Woodbury.
Here.
And Brad Fogg. Ooh, I am here. Our second order of business is the approval of the Zoning Board of Appeals minutes from September 26th, 2023. Is there a motion?
Georgia Woodbury, I move that we approve the minutes of the September 26, 2023 Zoning Board of Appeals.
Is there a second?
I second.
Any comments? All those in favor? It's unanimous. Our next item of new business is the establishment of the meeting calendar for 2024. You all have a copy of it. Or you should have gotten a copy of it. Is there a motion to accept? Do we want to change it? Do we want to leave it the way it is?
I'm fine with just the way it is for now.
Motion by Anthony. Is there a second?
I second the motion. Georgia Woodbury.
All those in favor? It's unanimous. Our next order is new business. We have 3 public hearings tonight. 1, 2, 3, yes. And we're going to start with Loon Island. Is there somebody here representing Loon Island? You want to step up to the podium, please? Tell us who you are and what's going on. And we're going to deal with the practical difficulty first,
Okay,
okay?
so I think we have 3 different applications in. Will Boyle, Loon Island. And we're looking at putting new signs up at 15 Main Street, both on the building for the businesses. And we have some representatives from the businesses here. And I think we already got a variance for the sign out front, and I'm not sure if we had to get another one. But we need a variance for the one down at 59 Portland Road as well.
We'll take the 59 Portland Road separately because it's a separate
Okay.
appeal. So it's my understanding from looking at your application, you're looking for 2 different variances for 13, 15, 17 Main Street, is that correct?
Correct.
One is for, and I want to make sure I get this right, for an additional sign that's 13 feet high and whatever it is wide, correct?
Additional, meaning that it's going to be replacing one of the existing signs that's there. So it's an addition to the one that we already got approved
Okay.
a little over a year ago, because there's 4 signs on site out on the road. We're taking 2 of them down.
So currently there are 4 signs.
Correct.
You're going to be replacing, for lack of a better word, 2 of the signs with the sign that was previously appealed by the board.
Correct.
What, 2 years ago, was it?
Yeah, roughly.
Okay. And you're going to remove 2 additional signs, 2 more signs.
Yes.
So ultimately, you'd be asking to have 2 primary road signs
Correct.
that are 200 inches high and I've lost it already, and we haven't even started. 200 inches high and 96 inches wide, correct?
Correct.
Mr. Chair, can you make sure that you're referencing that these are the entrance signs?
This sign, right?
Correct, yeah.
Okay.
You were just saying signs, I just
The
want
two,
to make sure
the
that
2
this is
main signs.
Yeah, it's the entrance signs.
Okay, the 2 entrance signs to the property.
So we'd be replacing the one on the north and the one on the south. The 2 in the middle would be going away.
Okay. Are you all familiar with that piece of property?
Yeah.
Would it be safe for me, I don't wanna presume or assume, the sign on the Manny Tie end, would that be stained or replaced?
Stain.
The two signs in the middle would be eliminated.
Correct.
And the sign where Lonnie Dog's cart is would be replaced with one that's already been approved.
Correct.
Okay. Looking at this map, I also see that the way the parking spaces are drawn in, it looks like a couple of curb cuts have also been eliminated?
They will be. That's part of the plan that we're working with the planning department to take those curb cuts out and then not redirect traffic, but make traffic one way on the front of the building and
Okay.
do angled parking. We have some challenges there that the only way to deal with them is to make it one way, really. So working with the planning and the fire department is how we came up with that plan.
Would the sign on that end, the entrance sign on the, let's see if that's, on the Manny Tie end, would that be moved off the property line and onto the new curb?
When we replace it, we would have to bring it up to code, so I'd like to keep it in that same spot, but if that means moving it back or setting it in, we will to meet the current
Well,
code.
the current sign is right on the property line, isn't it, between the two
It is, and I
properties?
believe you need to go 5 feet back from the property line, which, the one over by the laundromat on this end, that's gonna be problematic, because the property line goes right through the existing sign right now, so that sign's gonna get moved back like 10 feet from where it is.
Closer to the building?
Yeah, a lot closer to the building, which is gonna,
Wow.
yeah, it's not a good situation. The Manny tie-in one, that's not in the parking area, so that one can be moved back, no problem.
Because it looks like from where the curb cut is on that end, that the cars would be driving between Manny Tie and the new curb.
Correct. Which is gonna be one way leaving.
Okay.
That's
Is-
one of the traffic issues, is people trying to pull in there.
Yeah,
They're driving north and they stop traffic.
okay. I have no more questions. Does anybody have any questions? Anybody have any questions?
No, I don't think so. That one going into the parking lots, that's the existing, the one they've already had approved. That one's got to go in there quite a ways, but
It does,
the
yeah.
planning board, hopefully,
I have no more questions. So let's go down through the practical difficulty requirements. I got it. I got too many pages here and I'm suddenly lost. Well, this is a practical difficulty anyway.
back,
The criteria is briefly describe how your request meets each of the following. The need for the variance is due to the unique circumstances of the property and not to the general condition of the neighborhood. And you've written sign size, number of tenants, and building size. How many tenants are conceivably could the building hold?
Residential and commercial?
Yes.
31.
Well, let's go commercial, because your sign's really directed at the commercial end, correct?
So we look at the people in the storefronts, as the commercial. Across the front, there's 11.
Does that include the subway and the laundromat and?
It
all that?
does.
Okay.
Then there's 9 more on the second floor,
Are those commercial on the second floor or the residential?
commercial. And then 6 residential.
Okay, so there's 18 commercial total and 6 residential. And what you would be doing is, again, for the unique circumstances, currently there are 4 signs, and you're gonna be reducing the 4 signs to 2 total, entrance signs to 2 total, including the one that's already been approved.
Correct.
Okay. Does anybody have any questions?
I don't-
No, at this time.
Is there a motion for letter A? It'd be right there, Derek, if you wanted it. Is there a motion? Anybody?
I move the need for a variance is not due to the unique circumstances, is due to the unique circumstances of the property and not the general condition of the neighborhood.
Is there a second?
I second that.
A second by Anthony, and Georgia was the motion. Any discussion?
No.
All those in favor of granting or approving letter A? The motion is unanimous. Letter B, is there a motion?
Georgia Woodbury, the granting of a variance will not produce an undesirable change in the character of the neighborhood and will not unreasonably detrimentally affect the use or market value of abutting properties.
Is there a second?
I second.
Derek Shirley was the second. I guess I'd comment here, I like the idea because number one, we're granting a variance for a sign that will mirror in size and shape the one that we approved 2 years ago, or a year and a half ago, whenever it was. And very honestly, the 2 new signs look so much better than the 4 existing signs, and it will be more attractive from a street view than the others. All those in favor of letter B? Anybody opposed? Unanimous. Letter C.
Georgia Woodbury, the practical difficulty is not the result of action taken by the petitioner or a prior owner.
Is there a second? I'll second. Georgia moves, Fogg seconds. Any discussion?
No, you covered that before.
Yep.
They're gonna look a lot better.
All those in favor? Unanimous, correct? I didn't Or-
See your hand.
I didn't see your hand move, so I probably better ask. Letter D.
Georgia Woodbury, I move that no other feasible alternative to a variance is available to the petitioner.
Is there a second? Anthony seconds. I guess I'd like to discuss them. There might be other alternatives available. I don't think that'd be as fitting to the current approved sign, design, and dimension. And if the first and second signs that will be there will be within the code as established, then I think I think really there's no other alternatives, because he has to meet the codes, and he's bringing them up to code, really, by reducing the number of signs in a short distance. I mean, he's got 4 signs there, 150 feet? And that's a lot of signage in 150 feet.
Oh, yeah.
All those in favor? It's unanimous.
Georgia Woodbury, I move the granting of a variance will not unreasonably adversely affect the natural environment.
Is there a second?
I second.
I chuckle because I was gonna say, how can you affect the natural environment of asphalt and concrete? All along Main Street there. Any additional comments? All those in favor? Unanimous. And letter F.
Derek Shirley,
The property is not located in whole or part within shoreland as described in Title 38, Section 435.
Is there a sec? I'll second. Shirley motions, Fogg second. All those, discussion?
Like you say, we wish it was shoreland right there, right?
Well, it depends on what the DOT
No,
does
right,
when they
yeah.
rebuild the street. God, you never know. All those in favor? It's unanimous. I'll make a motion that Loon Island LLC, that Loon Island LLC be granted a practical difficulty variance from the standards established in the sign ordinance to install Tammy, are we approving one or two signs? Because he's got the one already approved.
Correct, he's asking for a second entrance sign. And actually, in the second piece of this is he's asking for two variances tonight at the same property, and that's why I wanted you to differentiate. An additional entrance sign so that he had the two, which you just did, and now he's asking for internally illuminated signs
Okay, we'll get to
over
that.
each of his commercial spaces.
I make the motion that Loon Island LLC be granted a practical difficulty from the standards established in the sign ordinance to install a second entrance sign, freestanding, internally illuminated signs at 12 through 15 Main Street in Gray. Tax map 043-402-053-000 in a Gray Center property zoning district. Is there a second?
I second.
Any discussion? All those in favor? It's unanimous. The second part of that appeal, practical difficulty, is the petitioner is asking to place 11 internally illuminated signs on the property. Where would the signs be going?
On the canopy. Do you remember where the China Gray sign was?
I do, yes.
Over China Gray. So we took that down when we were redoing the front of the building, the siding. And so we want to put new signs up there, but not every business has a sign over the business. Those signs that we took down were 3x9 signs. That particular one was 3x21 because there was a Coca-Cola or a Pepsi piece in the middle. And then there was one over the old hardware store. But we want to put one over each business, 2 foot by 8 foot illuminated sign, and have them all be uniform in size proportionate to the building.
Okay. Does anybody have any questions?
Mr. Chairman?
Yes,
I just want to make sure that you know that these are also internally illuminated.
it does say that, yes.
Okay, all right.
Now, I saw in that district that the sign ordinance allows for individual signs to be, I think it was 56 square feet, or 24 square feet per occupant. And there are more occupants than what you're asking for signs, which you're asking for 11, or 36 square feet per occupant, or 24 square feet per occupant in this particular district, the village. Okay. And again, this is a practical difficulty, so looking at the criteria for practical difficulty for these 11 signs, is there a motion I'll start. I move the need for the variance is due to the unique circumstances of the property and not to the general conditions of the neighborhood. Is there a second?
I second.
Fogg and Woodbury. I say this because other occupants in the same property, Subway and the laundromat and the martial arts center, all have individual signs. Two of them, I believe, are lit, internally lit, and the martial arts sign is externally lit, I think it is.
Correct.
So the other 8 occupants here, or 11 occupants, have no indication of which door in the building is the entrance to their building. And the signs are smaller than 36 square feet, so I think I just think it's good that,
The goal is to change the jujitsu, Subway, and laundromat sign to these new ones.
okay.
So they all look the same.
So are these included in the 11, or is this?
They're included in the 11, yeah.
Cool, that's even better.
We just gotta convince the jujitsu owners to change their sign. They happen to be here tonight. so.
Okay. Is there any comment from the public? Anybody?
We'll change the sign.
Okay. All those in favor of the motion? Unanimous. I move that the granting of the variance will not produce an undesirable change in the character of the neighborhood and will not unreasonably or detrimentally affect the use or market value of abutting properties. Is there a second?
I second the motion.
Again, I will say that I think that the property owners are making an effort to improve the appearance of the property as a whole and to better identify each individual business, so if somebody's driving through town, oh, they know where so-and-so is, and they don't have to necessarily guess anymore. And if the signs are, I mean, they'll know which entrance to use by proximity to the signs, and I think that's a good thing also. Any other comments? All those in favor of the motion? It's unanimous. I move the practical difficulty is not the result of action taken by the petitioner or a prior owner. Is there a second?
I second. There, Chair.
Shirley, Fogg, motion, Shirley seconds. Any comments?
I totally agree with it, so.
All those in favor? Unanimous. I move that no other alternative to a variance is available to the petitioner. Is there a second?
Georgia Woodbury, I second.
I think the sign ordinance has been written, and it's pretty strict, and of course, in the 2 or 3 years since it's been written, things are changing in downtown Gray, and with the projected project of the rebuild of Main Street and its subsurface infrastructure, I think anything that we can do to help improve the appearance of buildings and structures is the right thing to do here. And it's in line with a comprehensive plan in terms of traffic and appearance, visual appearance, where you can't put a buffer there. The building has to look better without a buffer than it currently does, so.
Yeah.
All those in favor? Unanimous. I make the motion that the granting of the variance will not unreasonably adversely affect the natural environment.
I second.
Any comments? Again, the natural environment right now is concrete and asphalt, and I think anything they can do to improve the appearance of the structure helps the downtown immensely, and it doesn't take away from any other business in that section. All those in favor? It's unanimous. And I move that the property is not located in whole or in part within the shoreland areas as described in Title 38, Section 435. Is there a second?
I second.
All those in favor? Unanimous. I motion that LOON Island LLC be granted a practical difficulty variance from the standards established in the sign ordinance to install 11 internally illuminated wall signs located on their property at 1315 Main Street in Gray, tax map 043-402-053-000 in a village center proper zoning district. Is there a second?
Georgia Woodbury, I second the motion.
Is there any discussion? Any comments from the public? All those in favor? It's unanimous. Okay, now we have a second practical difficulty from the same company for the property at 59 Portland Road. That's the property where the fisherman's net is, and the sweet spot, and the tailgate, and I'm not sure what the other new business is, but there's a couple of other vendors in the white building that abuts or faces Gray Road. And let's see what we got in the back here. I got it. Town of Wyndham, how may I help you? The applicant has submitted a picture of the existing sign. And any other business that's currently there, they have like a hang-up vinyl sign hanging between the two posts to identify one of the tenants. I drove by there to take a look at it today. Let's look at the criteria. Is there a motion for letter A?
Georgia Woodbury, I move the need for variance is due to the unique circumstances of the property and not to the general condition of the neighborhood.
Is there a second?
A second.
Second by Anthony. Any comments? I will comment, since the sign that has the hop shot and the tailgate, and I can't read the other ones, so stop by, shop. I mean, that property has been developed over the last couple of years, and there are more businesses there. And the signage is poor, it's old. I think it's a wooden frame there. That's all I can really say. I mean, I don't think it's any problem that anybody has created in terms of property, or if the sign is just old and it's outdated and its structure is old and failing, so to speak. So, any other comments? All those in favor of letter A? It's unanimous. Letter B, anybody?
Anthony Graybars, the granting of a variance will not produce an undesirable change in the character of the neighborhood and will not unreasonably detrimentally affect the use or market value of the abutting properties.
Is there a second?
Georgia Woodbury, I second the motion.
Any discussion? I would say that the new sign will certainly add value to the existing properties
Yes.
and not be detrimental to any of the abutters, because on one side we have like a wetland or the golf course type thing, and on the other side is Comp Motors. So, any other comments? All those in favor? It's unanimous. I motion that the practical difficulty is not the result of action taken by the petitioner or a prior owner. Is there a second?
I second that.
Second by Anthony. Any comments? All those in favor? It's unanimous. Anybody for letter D?
Derek Shirley. No other feasible alternative to a variance is available to the petitioner.
I second. Any discussion? I don't know what else they could do down there in terms of a sign. I mean, it's a long stretch of property, and there's no curbing anywhere along that property. So the sign where it currently is, at least it's in a protected place, and it's visible from, how long's the property? About like maybe 125 feet either side of the sign?
Yeah, it's 260 feet, so 130 feet roughly on either side. of the
Okay.
sign.
And on one side, you've got some shrubbery and bushes that caught motors that obstruct the view until you basically get right to the property line, so I think it's a good location. All those in favor? Unanimous. I would move that the granting of the variance will not unreasonably adversely affect the natural environment. Is there a second?
I second.
Derek seconds. Any comment? All those in favor? It's unanimous. And I would make the motion that the property is not located in whole or in part within the shoreland areas as described in Title 38, Section 435. Is there a second?
And Georgia Woodbury, I second the motion.
Tammy, that ditch that runs through there, that's not wetlands, is it?
No.
Sorry. All those in favor? Unanimous. I would make the motion that Loon Island LLC be granted a practical difficulty variance from the standards established in the sign ordinance to install one freestanding, eternally illuminated sign located on their property at 59 Portland Road, Gray, tax map 051-032-022-000, comma, in a commercial zoning district. Is there a second?
Georgia Woodbury, I second the motion.
Any comments? Any public comment? All those in favor? It's unanimous. Thank you very much. Somebody will get the letters out and signed and mailed out to you by next Wednesday.
Thank you, appreciate it.
I keep hitting the microphone. Boy, look at the place clear right out.
I know, goodness.
I guess it was Will's fan club that, I just wanna make sure they know the lights are gonna come on. You brought your fan club with you? Yeah, the lights were automatic.
Okay, let's see what we got going here.
A little bit too much.
Our next order of business is that William Chaplin and Greg Rand are requesting a practical difficulty variance for an additional lot coverage on property at 2 Storage Way, Gray tax map 028-026-002-000. The subject property is located in the commercial zoning district and is owned by Grayland Holdings LLC. Is there somebody here to represent the petitioner? Would you step up to the podium, please?
Good evening. My name is Chris Nagel.
Okay,
I'm an attorney, and I represent the applicants Bill Chapman and Greg Rand.
okay.
I
Mr.
live-
Nagel, with regards to the application, would you briefly describe how the request for the variance meets each of the 5 established criteria?
Well, we applied for 2 different variances.
Well, we're dealing with the practical difficulty right now,
Okay,
and that is the one,
I understand which one it is.
okay.
But
That's the one we're dealing
there's a
with.
story that you need to hear to give you the facts to show why we meet those standards. It won't be a long story,
Okay,
and I appreciate the fact that you focus on the review standards. I do this all over the place. I live about a mile away from the Greytown line, come down here all the time. Been a land use lawyer since the 70s, 12 years on the Cumberland Planning Board, been to zoning boards all over the state of Maine. This is my first time to have the privilege to appear in front of the town of Gray, which makes me happy. You guys are local. Anyway, and I will say this, when I sat on the board, I hated it when the lawyers showed up. I hated it. So, you got 3 of them in this room, maybe more. I'm not 4. I don't know. There's a lot.
well, that being said,
Okay, so what I'd like you to do, I'd like to use the exhibits to tell my story. So do you all have this package?
we do.
Okay, well, if you would all please turn to Exhibit 1. I'm gonna walk you through the first half of the exhibit, tell you a story, illustrate the story, and let you decide what to do.
Mr. Nagel, will the story you're going to tell us, in short, tell us why the need for the variance is due to the unique circumstances of the property and not to the general condition of the neighborhood?
Yes,
Okay,
I'll get there.
well, okay.
I'm sorry, this is an unusual situation, very unusual.
I know that. I've read this extensively. I've
Okay.
studied it.
Well,
And my concern is that people need to know that the zoning board can take no action on a decision made by the planning board. We cannot overrule any of their decisions.
and I'm not asking anyone to overrule the planning board.
Okay, so what the planning board did is not relevant to the decision that we have to make based on the request of a variance for the property. So I'd like you to confine your comments into the need for the variance.
With all due respect, sir, what the planning board did was fully justified and correct with the information it had available to it at the time. We're not faulting the planning board at all.
Okay,
But it is important to my client because the impervious lot coverage approved by the planning board did not allow for my client's driveway to be built. And I'll explain why if you'll just let me get into my story. I will get to the review criteria, but I think it's worth 5-10 minutes for me to show you these documents, let you know what happened, and we'll all be on the same page.
okay.
Maybe you've read it carefully, not everyone has, I bet some people in here haven't. So, with that, for on Exhibit 1, that's what my client owns. It's a plan that was approved by the planning board back in 2020 or so. September 18, sorry. The planning board only approved those 2 lots kind of at the top of the page that are on what's called Trestle Way. Okay, there are those 2 houses that have been built on an extended driveway. And the land shown as parcels A, B, and C was the rest of their property. The planning board didn't approve lots A, B, and C as separate lots. It's just how the plan was presented and signed. So my clients own A, B, and C, and right now, because this plan is more than 5 years old, parcel C is the parcel they're focusing on for this appeal. What's significant in this page is that you will see a yellow highlight on an easement that heads north onto the property that is owned by one of Scott Liberty's LLCs. So that's what my clients owned before anything else happened. And if you flip to exhibit page 2 for a second.
Just one question.
Yep,
Mr. Nagel, is the yellow highlighted area,
Yes.
the easement that was granted with the deed.
It was given to my clients originally before Scott Liberty got involved. And
Okay,
went
so it was
across
granted
Scott's
with the
Liberty.
deed of the property in question. Thank you.
And the deed that shows it is in the packet. So, note that in the planning board notes, shown on page 2, there was a condition that said no more land can be developed until Trestle Way is brought up to street standards, because it's just in the driveway now, or an alternative access way meeting town standard is created. So the planning board fully anticipated that my clients might develop alternative access, and that's just what they want to do. So let's go to Exhibit 2. Now, this is a plan of property, apparently some owned by Scott Liberty's LLCs today, and some may have been sold recently. For purpose of our discussion tonight, we're talking about the bottom lot, showing a building with a new 60-foot right-of-way next to it. You see that? So what happened in a summary fashion was that my clients and Scott Liberty had a conversation, 02, and Scott couldn't develop his land unless my clients released their old easement on it. So it was important to him to get rid of it. In exchange for that, Scott granted my clients an easement to get from Route 100 on the top left side of the page across the edge of his land down to my client's land. That image of the 60-foot easement is on this plan, plans in the Registry of Deeds, and that's what my client has the right to use. Okay?
Mr. Nagel, will you approach, please, and show me on this map? It's difficult for me to read even with my glasses on where the right-of-way is that you just talked about.
You want to show me?
I do, yeah. Your pen or mine?
I'm just gonna point to it.
Okay, so it's this section right here is the right-of-way that you're talking about, the easement.
Yes.
Okay,
My client's land is down here, and this is the Lewiston Road.
okay,
Route 100.
that much I finally figured out. I squinted my eyes a little bit.
And for the record, the parties are, the chair and Mr. Nagel are pointing to an easement shown and described with a little box that says
This one
new
right here.
60-foot right-of-way.
Exhibit 2
On
is
Exhibit
down
2.
from Exhibit 1,
Yeah.
so it makes it
You all
very
set?
close.
All set, thank you.
Anyone else have questions? It's important you understand this, and that's why I wanted to tell you this story. Okay, so, Exhibit 3 are two different deeds. The first one, called Termination and Release of Easement, was when my clients gave up their right to use that old yellow road shown on their plan, so that Liberty could develop his property and ignore it. On the next page, on page 5, is an easement deed from one of Scott's LLCs to my clients of that 60-foot easement that I just showed you on the plan. So there it is, September of 2020, there's a recorded easement, there's a recorded plan, and something you'll hear from later. If you flip ahead to page 7, you'll see that Scott imposed a condition that my clients would not use this 60-foot easement in a way that would interfere with Scott's use of his land. And my clients don't plan to do that. Driving across the corner of his land isn't going to affect his use. But you'll hear about that from his attorney soon. So let's go over to Exhibit 4. So that is part of Scott's Liberty's application to the planning board for his project, which consisted of a commercial building, a storage facility and a residence. It was gonna be a subdivision and needed site plan approval. And the problem with this plan, and Exhibit 15 has his complete application if you wanna look at it. It does not show that easement that he gave my clients less than a year ago. And if you look at Exhibits 16 and 17, you'll see both the site plan review ordinance and the subdivision ordinance required Scott Liberty to show all current easements on his property when he filed his application. And he didn't do that. Yes,
Mr. Casavakis?
Through the chair, just commenting, I think you referred us to Exhibit 4, but Exhibit 4 is a plan that was made back in 2010. Did you mean Exhibit 5? I'm just trying to help the board understand.
no,
Which is the
this,
2022 subdivision plan.
this is what Scott filed with his application.
Okay.
He filed in 2022, it, obviously an older plan. And you can check it in his application. I took it from his application.
Just
This
update.
is what he gave the planning board as his site condition plan, okay? Not as his proposed subdivision plan, but most planning boards require an existing conditions plan, and this was it. And this is the problem, right here. This is why we're here. It's because Scott Liberty did not show this on his plan as required. And so the planning board knew nothing about it. Now let's flip the page to page 9. This is the plan that Scott Liberty got the planning board to sign, showing his 3 lots, 2 commercial projects, a neck of land on the top of this page, with my client's easement not shown on it. Again, not my client's fault. And Scott Liberty is gonna argue that my clients are at fault for not showing up to the planning board to say, hey, wait a minute, he didn't show that easement on my plan. Well, that's not on my clients. My clients had an easement. It was in the registry of deeds along with the plan. Their engineer, their surveyor was supposed to show it on the plan, and he didn't. Maybe you can ask him why tonight. I've never heard an explanation. It's just either a horrible error or worse, meaning something intentional. Nonetheless, it is what it is, as people like to say. So, that's where the thing ended with the planning board. And let's flip to page 6 for a second. I'll start moving more quickly.
Exhibit 6 or page
Exhibit
6?
6, I'm sorry. I'll start moving more quickly, because these aren't plans that you need to focus on, but just so you know what's in here, this is my client's application for a driveway permit under your street ordinance with plans and information and the engineer's plan showing compliance with your street ordinance. So that's the application that led, and tabs 7 and 8 are the DEP permit by rule applications, because there was, if you noticed on that plan, there was a stream and a small wetland. And so my clients have permission from the DEP, most recently in Exhibit 8, to build this road driveway. So let's get ahead. We're almost at the end of these exhibits. Do you have any questions so far? Okay. Exhibit 9 is the letter from the code officer that we're appealing. She describes what was given to her and found in the file. And she concluded that Scott's Liberty's lot had already been developed to the maximum 65% impervious surface limit. And therefore, she could not issue a permit that would allow more of it to get covered with a gravel roadway, impervious surface. So my client couldn't use his easement because of what Scott Liberty did after he deceived the planning board. That's where we are.
Okay.
So my clients are appealing this. Some interesting facts. If you go to quickly Exhibit 11, that's the email at the top is one from me that I don't need you to read, but the one on the bottom is an email from your community resources, whatever, I'm sorry, I don't know her title, but your code officer was out on some personal reasons, as I understand it, and this lady was covering, and she wrote an email to Mr. Liberty telling him that the attorney advised that the easement must be approved as an amendment to the subdivision plan, which was good advice. She said, Mr. Liberty, our lawyer said you need to come back to the planning board and amend your plan to show the easement. Which is all great. The problem is Scott never did that. Another thing he did wrong, in addition to over-paving his site, or over-developing his site. And one of the reasons we're here is because the town hasn't done anything about that. Town's ignored it. Scott Liberty has collected rents. He's recently sold part of his property, I just learned. There's no consequences to Scott Liberty for what's happened. My clients can't get a driveway into their property with an easement they acquired before Scott Liberty was around. And that's just not fair. You can pick your legal terms, it's just not fair. So if you go to Exhibit 12, this is an email from Scott Liberty to my client where he acknowledges that he's developed 70% of his property with impervious surface, well above the 65% limit, and apparently has no plans to change it. And he's right, we're looking to add another 4 or 5%. And the code officer said no. That's why we're here. So, one question that is not in your bailiwick, but maybe you can influence the folks in the code office. Why isn't anyone doing anything to Scott Liberty for misleading the town and preventing my client from exercising? The town has every right to pull his occupancy permits until he goes back to the planning board. But the town hasn't done that. And so from our perspective, my client's perspective, not only has the town believed its planning board took away his easement rights, but the town's not willing to do anything to fix it. Even though it's obvious who the culprit is here. The person who's making all the money and not suffering any consequences.
Yeah, Mr. Nagel, we're not gonna look at that. That's not within our bailiwick, you're correct.
I
We're gonna
understand.
look at your request in the instances that would either affect whether your variance is granted or not, so.
Okay. Well, so, let me just give you some legal arguments. The code officer didn't need to deny the permit. The code officer could have, and you might direct her to if you so choose, to recommend that the council bring enforcement actions against Mr. Liberty and allow them to, force him to go to the planning board to leave enough room for my client's driveway. That's what would be fair.
Again, Mr. Nagel, we're not gonna be looking at the actions that the town has taken other than the denial that you submitted, or that the client has submitted, the petitioner has submitted for a variance.
I understand.
The town has legal counsel of its own, and the town can do what the town feels right, or the town council can do what the town council feels they wanna do, upon advice from their legal action. We're simply looking at the variance and you're laying out the circumstances to us as to why the variance should be granted.
And I was just describing that the code officer had another decision she could have made, and she didn't. So let me get
Should've,
in,
would've, could've.
let's get into the criteria. You've been very
Thank you.
patient with me, and I thank you for letting me give you that information the way I hoped to. So, you literally have three different three different requests, and I'll let you tell me which one you want to hear first.
Well, what I'd like you to do is point us in your manual where you would specifically address the need for the variance, so that we can, I know it's in here, I've
Can
seen
we
it a
just
couple
back up
times.
1 second, sir?
Sure.
So you can let me, so we've applied for a administrative appeal because the code officer made an incorrect decision. Or we've applied for two variances, a practical difficulty and a standard variance.
What we're looking for right now is the practical difficulty.
Okay, then that's what I want to talk about.
Thank you.
I knew we'd get there.
I knew you would too.
Okay. Let me see. I gotta find my page. Variance request.
You got it marked, right.
Okay, let's go to page 9 of my memo at the front of my book.
That'd be page 31 of the book.
Apparently I failed
Page
to
9 to
note.
page 8. I think it starts on page 8, letter A.
It's page 9 of the memo at the front of my book. It's not a numbered page like the
It's right in
exhibits.
the beginning.
This one?
Yep,
I'm looking at page 8.
8, yeah, you need to go now.
Well, I'm looking at page 8 because you have on page 8, the start of letter A, the land in question.
No, I'm sorry, you're looking at the exhibit pages, and, well, maybe it's numbered incorrectly. I'm sorry, you're right, I'm wrong. I have dyslexia for numbers. Usually I can get through a meeting without having to
No,
disclose it.
you're good. I know I had read it, so I just wanted to make sure that we get you in the right
I'm
direction.
used to saying, when it comes to numbers, you're right and I'm wrong. Page 9, how about that?
Page 8?
Well, page 8 begins variance arguments, page 8 is standard variance, page 9 is practical difficulty.
And that's where I want to be on page 9. Thank you, Jim. The practical difficulty appeal
This one.
is on page 9.
With you.
Are we all on page 9?
Yes.
We are.
Okay, thank you for sticking with me. Need for variance is due to unique circumstances, not to the general condition of the neighborhood. There's nothing wrong with the general condition of the neighborhood. What makes this property unique is that it has an easement for access that it cannot use. I don't know any other properties that have an easement for access that they cannot use. That's certainly a unique event in my personal opinion. B, the granting of the variance will not produce an undesirable change in the character of the neighborhood and will not unreasonably detrimentally affect the use or market value of abutting properties. This section of Lewiston Road is zoned commercial with mostly residences and several businesses, based on the many times I've driven on it. Adding a driveway to another residence won't affect the character of the neighborhood and will have no impact on the market value of abutting properties. C, the practical difficulty is not the result of the action taken by the petitioner or a prior owner. Again, we did nothing wrong. The practical difficulty is due to an error, to give a positive light on it, by Scott Liberty, the planning board decision to approve his project over the error, and the code officer's decision not to make Scott Liberty correct his error, or whoever decides that. That's why we're here. My client didn't create any of that. We didn't want to be here. No other feasible alternative is available. Well, if you want to look back to Exhibit 1 for a minute, if you want to, but you don't have to. They would need to develop Trestle Way up to town road standards from the Lewiston Road past the two new lots to the, between A and B, and over to C, where my parcel owned, and then they'd have to build a 1,600-foot driveway on top of a 1,500-foot private road, just to build one house. That's just not feasible. Simple English. The granting of the variance will not unreasonably affect the natural environment. Well, very little is going to be disturbed for this. There's a stream there. The DEP has accepted permit by rule applications with no objections. The property's in the whole or in part the shoreline zone. No, it's not in the shoreline zone. It does have a stream across it that requires a permit. So that is our presentation. I just want to address you all received a letter from Scott Liberty's attorney, Jonathan Davis. Just wanted to just respond to some of these things.
Very honestly, Mr. Nagel, I haven't reviewed it yet because we only got it tonight at 7
Okay.
o'clock.
Well, how about this? I'll let him say what he probably is planning to say, as long as I can rebut it when he's done. The other thing I just wanted to mention, and maybe you haven't even read it yourselves, but there's a letter in your, someone sent to you from KO Storage, who apparently on Monday, November 13th, bought the storage facility from Scott Liberty, the middle lot on his plan. They didn't know anything about this. Well, shame on them. This appeal was filed in October, and if they'd checked into zoning at all, they would have seen a problem. But nonetheless, someone else is now owns some property that may need to change by the planning board. This decision he made not to show the town what he was supposed to show continues to hurt people. And I hope you at least let my client get out from under his mistake. Thank you.
Okay, to continue discussion, is there a motion on letter A?
Well, we've advertised this as a public hearing. Maybe one way we proceed would be to accept public comment this time.
What are they public commenting on? Because there's not been a motion.
Well, they don't, it's advertised as a public hearing, they don't need a motion.
Okay.
It just is in front of.
Because I would
it's
open up the
application.
discussion at that point in
Understood.
time, but.
But it might be easier to have someone address the entire issue of practical difficulty variance at one time instead of on each criterion.
Okay.
You'll
We
get
can
to
do
the
that.
same place.
Is there anybody else, an abutter or something that would like to make a presentation? Thank you.
Thank you.
Is there a copy for other council?
We'll share. Do you want this, Mr.?
Scott, do you need us to make copies real quick?
I can share
Are you
it.
sure?
I can share it with this.
We'll
guy.
share.
Did you want to take?
You have an extra back?
Can we get a copy, please?
Brad, do you want to take a short break?
He's
Let
taking-
Inga go make copies,
Yeah.
and then we can return?
We'll take a recess until we can get some additional copies made, and who would like a copy so we don't overkill the copier? 1, 2,
Does
3.
everybody have a copy? That's,
We'll need 5 extra copies, 5 additional copies.
okay.
And we will take a 10-minute recess. We are back from recess. And we've opened up the floor for public comment from any party involved. And we have, who's at the podium now?
Scott Liberty.
Okay, Scott.
Mr. Nagel went about 28 minutes. I
Let's
don't-
not do time comparison, let's
I-
just present your case and we'll hear what you have to
I
say.
just want to make sure that I get the patient treatment that you gave him. I have a story to tell too. They're accusing me of this malicious conduct that I somehow purposely didn't show this to the planning board. It's not true. I hired an engineer firm, a reputable engineer firm. They handled everything from soup to nuts. I basically was a participant in the audience. There was nothing malicious done at all about this. They also say that I needed them to get rid of the 11-foot old woods road that goes through the front of my property in order to develop my property, and that's why I gave them the 60-foot easement. It's not true. And in fact, I make this offer to them publicly tonight. Let's just revert it. I'll give you back what you had, and you give me back what I gave you. No harm, no foul. I didn't charge them a penny for that.
Mr. Liberty, is there a 60-foot easement that's been granted?
There is.
Okay, thank you.
Yep. And they gave up an 11-foot. But I didn't, the 11-foot can come back. It doesn't affect my property at all. It goes right through the front of my property. When I deeded that property to them, I did not put in there that they could have impervious surface. Typically, when Billy or Greg or myself do right-of-ways, we always put the language in that says this right-of-way can be used for anything a town road could be used for. I left that language out. And I was concerned that if they did anything more than a woods road or cut their wood or whatever back there, that it would affect my cannabis grow. I have the only legally approved cannabis grow in the town of Gray. The only one. We're the only ones that came to the planning board and did it right. We didn't play under the radar like so many others are doing. We did it the correct way. So that's important to me. I've got well water. Their right-of-way that I gave them is 25 feet from the corner of my building. I mean, it's close. And before they go doing any more impervious surface, they should go to the planning board first and find out what the planning board's gonna require, nitrate studies, whatever, because that water's gonna run right to my well, it's right there, right in the back. So I put that in there, that they couldn't do anything that would harm my cannabis cultivation. Well, Billy Chapman wrote a letter to the town council, and he's basically mocking the cannabis grow, saying that it was not good for the town, and that my tenant was living there with a shotgun under his pillow. Nothing could be further from the truth. It was just an emotional statement and a little jab to go after my business. On the second page, I don't have exhibits, we'll call it the second page. The ordinance is clear. You can't have more than one curb cut serving a commercial property without planning board approval. They're gonna argue, well, they're gonna do a residential property. It doesn't matter. If they grant this and this impervious surface, it's right next to my driveway. So now it's gonna be opened up and people are gonna be driving into the back of my building. I don't have security in the back of the building. I have all the security in the front of the building. So, again, if they went to the planning board and they were granted this, the planning board could put conditions on them. You know, maybe put up a fence, maybe whatever. But that's gonna negatively affect my property. We're also considering going to Superior Court and asking for a declaratory judgment that they have waived that right. Because of his letter to the council, he has come against my cannabis grow, which I specifically put in there that he could never do. So if that happens, that needs to be aired out in Superior Court before he gets any variance. If he gets a variance. DM Roma says that he can't do a permit by rule. With the amount of impervious surface there, they have to do a tier 1 application. The problem is they went to the DEP, even though I had had this work done, because they were selling me the property, I'd had the soils work done in May. They didn't even want me to give it to them. They said, no, 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 we don't want to know. But I gave it to them anyhow, which showed that the property has not 1, not 2, but 6 vernal pools on it. I was warned about this by Rodney Boynton when I bought the property originally. I said, what about the back property that Chapman and Rand own? He said, stay away from it. It's got vernal pools all over it. When they agreed to sell me the property, I said, I gotta do soils test. They said, okay, do your soils test. Well, I come to find out there's 6 vernal pools out there, and each vernal pool, you gotta be 250 feet around each one that can't be touched. They didn't disclose this to the DEP when they got their permit by rule. There's a lot of things they didn't disclose. They wanna sneak in there, get a driveway in there, and put whatever they do in there on the QT. They say they didn't have any agreement with me. Well, that's not true. For a year, I've been negotiating with them. First, they were gonna sell me 2 acres. The reason why is I had a school interested in buying the property, but they didn't think there was enough parking. So I went to them and said, I'd like to pick up a strip of land. Billy came back and said, we'll sell you 2 acres for $60,000. I said, okay, we got a deal. Now, I went to school with these guys. I really hate being up here, having this conversation. I've been friends with them my whole life. Apparently, it's been a one-way street. I found that out later. When it came time to buy the 2 acres, Billy said, oh, Greg changed his mind. Greg wants you to buy the whole 15 acres. He wants everything to the left of Trestle Way gone. Well, that's all the crap. That's all the land with the vernal pools. We're gonna develop everything on the right side of Trestle Way. I said, how much, Billy? He said, $170,000. I said, I cannot justify $170,000 for that land. But we went back and forth, back and forth, back and forth, and I finally said, I'll pay it. I'll pay you the $170,000. Good, we got a deal. No, we don't got a deal. Billy comes back to me and says, Greg don't want to sell it now. I said, Billy, first you're gonna sell me this, you tell me Greg doesn't want to do it, then you're gonna sell me this, you tell me Greg's gonna do it. I said, well, I'm not waiting around. I'm gonna develop my property. So I did develop my property. They could have come to the planning board meetings, they could have picked up on that mistake that the engineer firm made, they could have voiced their opinions, they didn't. Well, then they find out they got a problem this spring. I met with both of them out there. Said, let's work a deal. We'll put your driveway over in the front where we already got a curb cut. The town's gonna have a hard time giving another curb cut on this commercial lot. Let's put it over here. I own the front area for storage units and for my building. I kept the rights to that. I said, we'll put you right out here where the old Woodward Road went, and that's the nice, easy place to get to where you wanna build. We'll think about it. Thought about it, and they came back and they said, this is what we're proposing. So they proposed moving the 60-foot right-of-way they have now, flipping it south to Dunbar. That's what this is what they sent me. I didn't send this to them, they sent this to me. Flipping the current right-of-way that's 25 feet from my building towards Dunbar. And they wanted to own it. So they didn't want to deal with this language anymore about having any effect on the marijuana grow. I said, well, that's far enough away from my building. That gets you 130, 40 feet away. I think that will work. And then they were gonna give me a strip of land on the back, which would, then we wouldn't be in violation of the impervious surface. I said, listen, Billy, are we all set to do this? He said, well, Greg wants $10,000. I said, I gave you guys the 60-foot for free, and now you want $10,000. He said, well, Greg doesn't believe in letting go of any land without getting paid. I said, it burns my ass, but I said, I'll do it. I got the floor, Chris. I respected you when you had the floor. So I have a short 6-minute audio recording of me and Billy Chapman. I have many recordings, but this is a 6-minute one in July where Billy Chapman says, we're gonna fix this problem and we got a deal. And I'd like the board to hear it for the record and go from there.
Advice, Jim?
We understand the board understands there's a story, and there's a reason why each party has its position. But the question right now is whether the applicants meet the standards for practical difficulty or variance. And that's what ultimately Mr. Nagel got to, and that's what the board would like to hear from you, a response to that.
So I'm-
It understands that there's contention between the parties, that each has a story. My suggestion is that listening to tape recordings of other conversations about land transactions, it's getting a pretty far afield.
Well,
Well, I have a tendency to agree. What we're here, again, we're looking at the variance. We're not here to mediate personal disputes
but this
and
shows
what
that
was said or what wasn't
they
said.
don't need a practical variance. They fixed the variance, and I have it in an audio recording, and I have it in their email to me, their text message to me, showing me what we're gonna do. And not only were they gonna fix the problem, because they've known about the problem for a year, I was gonna pay them $10,000. So they don't need a practical variance. They've got tons of land. They've got 30 acres of land, and all they gotta do is give me just a little tiny slip, not give me, sell me a little slither, and now there's no more impervious surface issue. So anyhow, I mean, he told his story. I wanted you guys to hear it. So, because he's up here saying, Mr. Liberty did this and Mr. Liberty did this, and you know what it feels like to be a punching bag. I don't like it. And I want the truth to come out. So he gets to build a record saying, I'm a piece of crap, when the truth is, they're the ones who have lied to me non-stop. And I've got a lot of recordings, but this one is beautiful. So that's all I've got to say.
Mr. Chair, members of the board, my name is Jonathan Davis. I'm an attorney from Freeport, Maine, with the Office of Powers and French. I represent Grayland Holdings LLC. And what may be a bit of a change, I'd like to talk to you about the standards of your ordinance and the facts of this case. I'd like to talk to you, if I may briefly, about the practical hardship variance and why Grayland Holdings believes the applicant does not meet the standards as set forth in your ordinance. In some of the earlier meetings, Mr. Chair, you were referring to various sections of the ordinance and the criteria, and I apologize that I don't have my presentation conveniently labeled to, section A, section B.
That's fine.
But in terms of this hardship, the hardship criteria, Grayland Holdings firmly believes that this hardship was in fact created by the applicant. If you take a look at the applicant's Exhibit 1, that's their subdivision plan. They designed this. They configured this. The choices of their lot layout, the choices of where to put the road is on them. We've seen the bumper stickers and the signs, not my monkey, not my circus. Well, this is their monkey. This is their circus. This is their project that they designed. They had full notice. Note 15 on page 2 of their Exhibit 1 indicates that if you want to develop land further, you're either going to have to build trestleway up to town standard or come up with another means of access up to town standard. They could have designed their project any way they wished. In fact, you heard Mr. Nagel say, as part of his presentation, the planning board did not approve lot A, B, and C. That was, quote, just how it was presented and designed to the planning board, just how it was designed and presented to the planning board by the applicant. This is clearly their hardship. This is clearly a need that they created. The problem that they have not only started with their subdivision approval, their design, their plan, their configuration, their choice. The record and the exhibits also reflect the exchange of deeds. I believe that's Exhibit 2, it might be Exhibit 3 of the application. You heard Mr. Liberty say that it was an old 11-foot woods road that they gave up, and they got a 60-foot wide right-of-way instead. They did not negotiate the right to pave that right-of-way. The 60-foot right-of-way does not include the right to pave. It does not include the right to construct a means of access sufficient to provide a residential dwelling. It is an easement for ingress and egress and, quote, all kinds of utility services. Nothing about paving, nothing about improving, and I cited some law in my submission there that talks about that the grant of an easement or a right-of-way does not automatically include the right to pave or improve it. Again, a second time, they created the problem. The third time they created their problem is refusing to accomplish the discussions that Mr. Liberty was relaying to you. So again, in terms of did the applicant create the problem? The answer, we believe, clearly is yes. Turning to the feasibleness, the feasible criteria. There are no other feasible alternatives available to the applicant. Again, your ordinance does not define the word feasible. The Maine Supreme Judicial Court, we call it the law court, says that undefined words are given their ordinary and plain meaning. I've cited the Cambridge Dictionary that says feasible is able to be made, done, or achieved. Feasible is not convenient. Feasible is not the cheapest way. The applicant's submission says, or implies at least, they could extend Trestle Way. You heard Mr. Niggle during his presentation talk about the driveway they could build. There's no suggestion that there's some unique geographic feature that prohibits the extension of Trestle Way. There's no suggestion that the applicant doesn't have the legal right to do that, to extend it through their own land on the subdivision they created. So from our perspective, they fail on the feasibility standard as well. The one-lettered criteria that I do know is criteria B. That's the materially diminish or impair the value. We've heard nothing this evening other than how their project will materially impact and diminish the value of Grayland Holdings lot. We've heard Mr. Liberty talk about the cost of security and all that sort of stuff. We've heard talk about the impervious area and how it's maxed out. The CEO has made that determination. And so if they're able to increase the impervious area, well, guess what? That materially diminishes and impairs the value of our lot. Something Mr. Liberty, as the principal of the LLC, expressly included in the easement deed that they couldn't do. So in terms of the practical variance standard, we firmly believe that the evidence shows that they're not entitled to that, and that therefore that request should be denied. And much of the same logic, by the way, Mr. Chair, I don't want to jump ahead of myself. I'm not going to rehash it if we get to the standard variance argument, but I'll just simply recap what I've just said, most of what I just said in that respect as well. So I appreciate the board's time. I'm sorry I didn't have a story to tell. I'm sorry if I bored you with law and throwing out some cases at you, but again, As a real estate attorney for 30 years, including being a planning board member and former chair of a zoning board of appeals, there's no nexus, and as the chair noted, we're not here to overturn the planning board decisions. We're not here to bring an enforcement action. Does the application meet the criteria? And we submit no. Thank you.
I have a question for you now.
Please, sir.
If the abutter, GH Holdings, had not increased their impervious surface beyond 65% and gone to 70%, would we even be here?
The answer is yes. The answer is because of the other impacts on the operation that we're talking about. Because, well, we'd either be here or we'd be in Superior Court because we'd be litigating whether the easement includes the right to increase the impervious surface. So certainly in terms of, well, Mr. Chair, I'm not going to implore upon you to be too courteous to me, but 30 seconds. The answer I firmly believe is yes, because we'd be here based on the ordinance's provisions regarding curb cuts and not more than one curb cut for a non-residential use. And here we have a non-exclusive easement. So Grayland Holdings owns the land that this right-of-way crosses and would be absolutely perfectly allowed to, as the owner of the land, to make a circular driveway with 2 curb cuts accessing its business. And so we would be here because that second curb cut would likely, in my opinion, have been denied by the CEO if the planning board didn't approve it, and so we'd be right back here again. Sorry if I took too long.
No, I'm not sure you answered my question, though.
So the answer is yes, we'd still be here. And if not here, we'd be litigating this, or debating this in another forum.
65%.
So the question is
We're
that
at 65%, he couldn't go anymore, that's the question.
if he had stayed within the 65%,
Well, it's still the maximum.
the allowable impervious coverage at the time, if GH Holdings had not exceeded, which they can do, I guess, the 65%, and the applicants wanted to put in their driveway and do an impervious cover, then everybody would still be in within the impervious cover.
Well, again, my understanding is that the 65% is the maximum of the ordinance.
Or whatever it was
And
you started at.
so if
there was an increase,
there was
was
space
there not,
available.
Scott, from the beginning to 65%?
We don't know exactly. We're at the maximum for sure, 65%. We don't know if we're 65 on the button or 70. So, but we're at the maximum. We do know that for sure.
Okay.
Okay. So there can't be any more added.
Without a variance. So we'd still be here.
Okay, so, go ahead.
Yeah. But if you hadn't exceeded the 65%, would we still be here?
Even if I was at if I'm just at 65, you can't put any more in. So their right of way is in the woods. It's not part of my parking area.
But it's part of
Part of
the
the lot.
the lot, though.
Correct. So I could go to 65%, which I did. There can't be any more than 65%. So if the town was to say, yeah, you're at 70%, and we want to have an enforcement action, all I have to do is grass 5%. And we're back to the 65.
If I may, I think the question the board member had was, if you were under 65%, say 60, is that, then,
Yeah.
and this road weren't going to take more than 5%, would we be here?
Probably not, except for the language that I put in there. We may not be in the zoning board of appeals, but we would be in Superior Court.
I think that was your counsel's answer. Thank you.
Would somebody point us to the exhibit, if there is one? I don't recall seeing it. of the deed that has the expressive language that prohibits the applicant from putting impervious cover on the road they are seeking to build?
Doesn't say that, sir.
Well, would somebody point us
It's on page 7.
of,
It's an easement that says we can't unreasonably interfere with restrictions.
okay,
Page 7 of the exhibit.
page 7 of which
Right here.
section?
We talked about it.
Okay, I just want to make sure that I,
Is the easement, is it here?
page 3, section 3, page 7.
If I may, Mr. Chair, may I approach the board? It's, what we're looking at is tab number 3, the purple tab in the spiral-bound book.
Okay, and I've got it now, page 7.
And page 7 of that.
Okay,
And that's part of a deed that begins at page 5.
Correct, sir. Correct.
And that deed conveys the perpetual right and easement for passage of pedestrian and vehicular traffic and for the installation and transmission of all forms and kinds of utility services over a strip of land 60 feet in width. I'm reading from page 5, the beginning of the deed. And then it has the exhibit A,
The meets and bounds.
meets and
yes.
bounds description. And then the next page, the last page of the deed at page 7, contains the language that the chair was asking about.
Correct, the last sentence there. Grantees further acknowledge and agree that their use of this 60-foot easement will never interfere, not unreasonably interfere, but will never interfere with the grantor's use of Lot A.
okay, thank you.
Thank you.
I have a follow-up question. How would the applicants making a driveway with an impervious surface impact the current use of the property as it's being used?
I'll answer that in, I think, 3 different respects, if I may. Respect number 1 is the issue that we've been talking about so much, the impervious surface area. So to put in a driveway to town standards, as I understand it, the town ordinance classifies gravel as being an impervious surface. So in order to improve the means of access, we're necessarily increasing the impervious surface to an impermissible level. There's one impact. The second impact, as you heard Mr. Liberty speak about, is the proximity of that improved driveway to the well that provides water to the former Sear auction building. The third impact we've heard is the concerns regarding buffering, fencing, security, and those other similar issues. The fourth way that it impacts us is it puts us squarely in violation of the curb cut limitation. So those are the 4 impacts.
Okay, thank you. Mr. Nagel,
Respond to these comments, please.
as long as you don't get into the personal nature of he said, she said, yes.
I never started that, and I
Well,
don't intend to get involved.
I'm just cautioning in advance
I
that
didn't-
we don't want to hear he said, she said.
I didn't think it was relevant, but
Thank you.
I'm glad you let Mr. Liberty say what he wanted to say. So I think, let's start where you finished. Can you please turn to plan number 5 in your notebook?
That's it. You got it in the large one here.
That's not the same plan, the large one. It's, I really
It
need
isn't?
you to see plan number 5 in the notebook.
But you can't read it.
Well, I see the difference is a circle and some red lines.
Well, this more carefully illustrates the point I want to make.
Okay, so,
You
we're
look
looking,
at it too,
we're looking at this little
I don't know
corner
where
down
that
here.
plan came from. But my point is, if, no matter which one you wanna look at, the driveway entrance to Scott's 2 commercial projects is about in the middle of his property, where it says Lewiston Road. my clients want to build an easement across the stream, far to the right-hand side of the page, which is going to be a gravel road that leads to one house. And they never answered your question of how a gravel road against a corner of the property they do not use will adversely affect their property. He couldn't answer your question because there is no answer. As to the curb cuts, my client's building a house. There's no limit on driveways for a house. I don't know why they raised the issue. On pavement, my client doesn't need to pave his driveway if that's a problem for Mr. Liberty. The fact the deed says you can't pave it, the deed expressly says this is for ingress and egress. The cases that say the words right-of-way don't allow you to dig up the road are because the deed only says the words right-of-way. As your own attorney pointed out, this deed says, well, let me read it. Mr. Liberty's deed that he signed says that we can have a perpetual right and easement for passage of pedestrian and vehicular traffic, etc. And yet he stands up here and tries to tell you that his easement didn't allow my clients to build a roadway based on some irrelevant case. Don't listen to it. Another point that stretches the imagination, Mr. Liberty is a very smart man with an excellent memory. He's told you all about this, that, and the other thing. Remarkably, this experienced developer who's very intelligent with a good memory forgets that I gave an easement to someone last year. Oh, I didn't know there was an easement there. It's all my engineer's fault.
Mr. Nagel, we're not gonna rehash that.
Well, I'm just trying to refute his statement.
No, you're
That he
rehashing the
didn't
same
know.
thing. It's he said, she said, and
No,
we've heard
it's-
that now.
Okay. Vernal pools. Number one, they're nowhere near my client's project. Number two, my client never gave them permission to enter their land and do this study. It was a major act of trespass. So, and it's not relevant. The point is, all this stuff is smoke and mirrors because he can't and won't explain why he deceived the planning board. So,
Again, that's not within our venue. We wanna stay away from that.
okay, as to the
We're gonna
points
stay away
made,
from that.
so the points made by Mr. Davis, the planning board's plan specifically contemplated alternative access. So to say we created our own problem just doesn't, not supported by the evidence. He's saying we created a problem by refusing to agree with Mr. Liberty's request for an agreement. That's a he said, she said. My client's position, there never was an agreement. And if Mr. Liberty thinks there's an agreement, this is not the place to fight it out. This is not the forum, and it's not relevant. So, no pavement, residential curb cut. And the other point is, as in this letter, although not said tonight, my client had no obligation to go to the planning board when Mr. Liberty's project was being approved, to make sure Mr. Liberty didn't forget to put it on his plan. There is no case in the state of Maine that says you lose your easement rights if they're on a piece of property being reviewed by the planning board, which doesn't show your easement. That's just hopeful, wishful thinking. It's not Maine law. My client has an easement. No one can take it away from him in this building. And we hope you give him a variance so we can just end this for now with respect to my client's property. Thank you for listening.
Thank you. Ms. Munson, I have some questions that I'd like, if I can.
Before we get there, is there anyone else from the public maybe?
Oh, yeah, well, it's kind of follow-up to some of the things you said, but does anybody else have anything before I ask Ben to put his head on the chopping block, so to speak.
Evening, Mr. Chair. My name is Ben McCall. I'm an attorney at Jensen Baird in Portland. I'm representing the code enforcement officer who, for the record, has no position on the variance. I think we made that clear in our statement on the administrative appeal, but I'm happy to answer your questions to the extent that I can.
Could somebody please, for sure, because I have not reviewed this, I admit it, what the requirements are for curb cuts in the residential commercial district? I mean, what is a curb cut, really, if there's?
It's right in the ordinance, so I have.
That's okay, we'll get somebody just to briefly state.
So the only thing that I think I can add to that, I'm not disputing, I know Attorney Davis is, excuse me, brought that section of the ordinance to your attention. The only thing I can add to that is that the application, and I think respectfully, this goes more to the administrative appeal than anything else, but the application that was submitted was for a driveway to reach a proposed residential property. And so from the code enforcement officer's estimation in reviewing that application, this section of the ordinance didn't come into play because the application was for a driveway to reach a proposed residential property.
Okay, thank you. I mean, everybody's throwing around the curb cut, and Ms. Woodbury has pointed out to me that curb cuts only refer to commercial property and not a residential property.
I think a curb cut is a term of art when used in certain circumstances. I think the restriction that's been noted earlier, thank you, Chris. Yep.
It says, unless specifically approved by the Gray Planning Board as an integral component of a duly approved
Right.
application such as a site plan review, conditional use and/or a subdivision, only one curb cut for non-residential purposes shall be permitted on any parcel,
Right.
which might lead me to believe that the Liberty operation on that one single parcel in the middle with the storage buildings and the parking is a commercial lot, and they could only have one curb cut in it anyway, and not put a loop driveway in.
I think, again, somewhat outside the scope of a variance appeal, because by its nature, a variance is asking for relief from certain sections of the ordinance. I think the key word in that section is purpose, not lot. So, in my interpretation of that section, and Tammy can poke me if I'm misinterpreting what
It does say purpose.
what her reasoning was. But again, the application that is, again, a later point on your agenda was for a driveway that necessarily would have its own curb cut, but the purpose of that curb cut was for a residential purpose and not a non-residential purpose. It is, in theory, to reach a residential building lot. If that were to change, that would potentially be a ground, certainly, to deny the application. And again, not to get ahead of ourselves on the agenda, but one of the things to keep in mind is that the possibility that that particular section of the ordinance might be violated was not one of the grounds for denial of the driveway permit itself. So it's outside of the scope of the administrative appeal, and I think for all the reasons that are said, at least it's the town's position, that section's not relevant to what you're reviewing tonight. I know others may disagree.
I think it was more of a curiosity question, where
Sure,
again, I
fair
have
enough.
not gone and specifically looked for the curb cut definition. And
No, again,
people were saying curb cut, curb cut, curb cut, and I wanted to make sure that we had an understanding of curb cut.
Certainly, just as a general matter, a curb cut, certainly, a curb cut generally refers to any, just to that, a cut in the curb, but it can be for a whole number of purposes. This restriction requires planning board approval if there's gonna be a second curb cut for another non-residential purpose, and that's not what was at play here.
Thank you.
Sure.
Are there any other comments from the public? Any additional questions from the board members? Anything at all that you want specified or we need to make clear? Anything? Kami, I do have another I want to know question. I don't think it's a legal question. At this time, is the town aware of any proposed development above and beyond this one structure for that driveway?
No,
Thank you.
you're talking about the land
Well,
that
somebody was saying.
Chapman and Rand could
development,
potentially develop.
Yes,
There's no proposal, there's no application for any type of planning board approval for that parcel that they own that they're requesting this variance for.
thank you.
Yep.
Does anybody have anything? Any additional comments, information? Mr. Davis?
Thank you, Mr. Chair. Just to keep this brief, council read, council read the easement, and the point that I make with respect to, again, I don't want to go down the rabbit hole too much, but again, it's not an exclusive easement. So Grayland Holdings has every legal right to make full and unfettered use of this easement area, whether it's for its commercial purposes or otherwise. So that's why it's mentioned in our submission here regarding the curb cut issue versus residential, non-residential purposes. Thank you.
Don't sit down now. Curiosity has got my,
Of course.
how would the potential approval of a variance allowing the impervious surface to increase on that, we'll call it a driveway for the sake of the driveway, within the easement, how would that impact what appears to be the storage business of the current property? I guess that's what I'm kind of saying, I don't understand, because people are saying they're concerned about access to the back property, they have to put a fence up. If there was just a simple driveway there, a forest road, if somebody mentioned, I could wander up a forest road onto any property out there I wanted to. So I'm kind of wondering how an improved driveway would change that.
If I can correct or I think maybe a misapprehension, is if you take a look at Exhibit 5, and if you orient yourself to Exhibit 5 with the spiral bound part up to the top as I'm holding it here.
Is that this? Yeah, come right up and tell us.
Yes, use the big green one then.
Yeah, okay, let's do that.
So the big green one represents the 3 lots that were approved by the planning board. On the far left-hand side is a lot that was improved with a residence.
Correct.
The middle lot was owned by Odessa Properties and was recently sold to KO Holdings, from whom you have a letter. The storage facility is in the middle, is that middle lot. So when you're asking questions about the right-of-way impacting the storage facilities, that's not the parcel we're talking about. We're talking about the parcel to the far right-hand side, the old Sierra Auction Building, that's the Grayland Holdings. So we're not suggesting that necessarily this driveway on the far right-hand side over the wetlands would impact the storage unit, the storage property, the middle property.
Okay.
We're talking about the property to the right, Grayland Holdings, the former Sierra Auction Building.
How would a driveway impact the former Sear Auction Building? From a security point of view, or
So,
what would be the negative impact?
Can I address
Well, let me yield to Derek for a minute.
Same question regarding this building. Is this the building that you have your medical cannabis facility in? So from that perspective, I do understand slightly why they do have a fear versus it being in an empty building. Coming from that world, I understand that, in this day and age, more than ever, you want to make sure your assets, your plants, are kind of protected at all costs. And that it is a judgment thing, just because I might not think his plants are in danger because of this, I'm not allowed, I don't think I can make that fair judgment. Personally, just because, you know, I don't know how your layup is, I don't know how your general security is, etc. But I, at least personally, do understand your concern of the security at that position, simply for being a cannabis building. I mean, cannabis is one of the most targeted businesses in the state, so I definitely understand why you'd have that fear. But that being said, too, it's one of those things where and I'm just making sure I understand too, you're worried about a gravel driveway due to the well water contaminating your plants? Is that really your big concern? I'm understanding? Okay. I just want to make sure I am understanding. I don't want to assume. This is not a place to assume. So I just want to make sure I understand. So they're actually, there's actually a lot of, this is actually a little deeper than we probably realize, because, you know, I definitely, if you're using well water, contaminated things can get into the product, which would make his product, which would affect his business. Heavy metals being one of them. Heavy metals could easily get into his water. Arsenic. I'm just throwing random heavy metals that I know can then be contaminated in the water. That could affect your plants, which could affect your business. So for me, it's I understand your fear, but at the same time, it's one of those things where there is a guideline we have to go by. So it's one of those things where I also feel that I want to make sure we understand what businesses we're actually protecting, because obviously a storage business have different protection needs than a medical cannabis business, and I personally understand that.
Well, I have to admit, I did not know that was what that building was being used for.
No, I didn't either.
Like I said, it was the only approved one in the whole town of Graham. We're the only approved cannabis grower in the town.
I'm kind of just wondering out loud, I wonder how many of the 7,000 people live in town that know that that's what that is. I didn't know.
And because you didn't do an onsite, I'm just saying, because you haven't done an onsite, you wouldn't realize when he puts this driveway in, it is literally right next to my building. And so what's gonna happen is, you say, well, I'm a commercial builder, commercial grower. People are gonna drive in there. Unless they put up a fence, you're not gonna stop people. People get confused as it is now. And they're gonna drive right in that driveway and drive in the back of my building and drive out to the front. You can't stop them unless, if they were in the planning board would make them do certain things to protect the abutter. But if you were on site and saw it, it's from me to you, and it's already impervious surface, so when they take from you as the grass, when they take that out and make a curb cut, people are just gonna drive right in the backyard. They'll go up to the house and they'll go to my place.
How do they get to your place by your driveway?
Yeah, I'm not understanding how they're able to get,
I mean, if they follow the
Behind
driveway, they
your
can come into
grow
the guy's
facility
garage. I mean,
from
how do they
a-
get from their driveway?
sure.
So.
And Scott,
We need to see this, Scott?
Okay.
We're entitled to see what you're telling me.
You can see anything, Chris. I'm not gonna hide it for you. I buy you drinks when you.
Hey, guys, let's just keep the business, please.
So, yeah, so here's the building. The right-of-way is 20 feet off the corner of my building.
Not true.
Let's not argue right now, he's making a case, you can rebut.
If you did the onsite, you'd see where the pin is. Okay, so when you drive in here, this is already impervious surface. This is where I drive in now. We share with the storage unit. This is our curb cut, right here. We
Okay.
drive into this building, and we enter the building from here, here, or here,
Okay.
not from back here. Now, if they put a driveway in here,
So if you were to drive right here,
yeah,
you could drive around your building here?
I could
It's-
drive around my building here. But people know they're driving in, they don't
Right.
think they're driving into a home.
Sure.
So when they come in down the road here and they see a curb cut,
Yeah,
they're gonna drive in here, and then they're gonna go, which way do I go?
right.
Left, right? Because he's gotta go across the brook. His property's here.
Sure.
Okay, so they're gonna drive in and they can just, now they've driven in behind my building.
So are they building a drive off an existing drive?
No.
So how
They're
did it-
building it next to it,
Okay, so, in other words, there's a road behind your building.
parking. There's a parking lot behind my building that's right up against their right of way. Their right of way becomes woods.
Okay. That's cool. Thank you, Mr. Chair. Oh, geez, a chair that doesn't roll on the carpet, I love it. Just, work out my calves. Mr. Nagel?
So this is where they want to put the house. What he was just saying.
What I don't understand is if someone wants to break into Mr. Liberty's building, they don't need to use my client's driveway, they can use the driveway themselves. If they want to be secretive and get in under the radar, they're just gonna walk through the woods. So this statement that this driveway is going to cause unreasonable security issues has no basis in fact. You disagree?
Yeah, very much so. So, my question is for you then, how many cannabis operations have been broken into in the last year?
Not relevant.
It is, because this is a cannabis operation.
No, the question is, will this driveway make it easier to break into a cannabis operation or not? That's the issue, not whether it's possible, and what you're telling me is it's
No,
likely.
you're saying based on facts, and you're saying, why is this particular issue, why is this building causing issue? And there's a track record in the last year and a half, you can look it up, the cannabis laws, cannabis issues, that's a thing in this state, that break-ins with cannabis has been an issue. It
I'm not
has.
disputing that.
I mean, then you're saying like, well, a robber's not gonna think, what driveway, hey, here's one section, here's two, they're gonna pick any one they want. So to me, that's just giving them another way to do bad things.
I respect your opinion, sir, I don't agree with it, that's all.
Oh, fine, good. Let's not get into an argument about a driveway
Well,
and
and I
marijuana
just
break-ins.
want to make another point
Okay?
regarding the speech about heavy metals. I'm not an engineer, and I don't know if this gentleman is either, but my strongly held belief is that people on a well have a drilled well that goes down into, sir, I'm
Mr.
listening.
Nagel, we are not going to get into heavy metals and the science of it. We're looking specifically at whether this variance can be granted. I mean,
Well, sir, all due respect, one of your board members, who I respect, articulated a concern regarding contamination. And I think I'm entitled to respond to that concern because he raised it, and that may affect his vote.
Well, it won't.
So that's not an issue for you.
My thing is, I said like heavy metals. That's one of many contaminants that can be in cannabis, but I don't have time to explain cannabis one-on-one to you today. I really
Okay,
don't.
no, it's not-
how about contaminants? So
This
here's
is
my
a-
point. Would you
Gentlemen,
would you let me finish
He's
my
been nice to me.
sentence?
He's been holding me back because you're really
Gentlemen.
wasting my time.
gentlemen, this conversation about heavy metals is gonna stop, and it's gonna stop right now. It has no bearing directly on the variance
I agree.
itself.
I agree.
So, are there any other public comments?
I'd just like to say I respectfully disagree with the board member's position on contaminants. That's all.
Are there any other public comments of any type? Anybody else? Seeing none, I will close the public hearing. We will now look at the practical difficulty. Oh, I've got a question. Boy, oh boy. For the town of Gray. Is there a specific setback for impervious surfaces or roadways from wells?
No.
Thank you. So there's no like residential requirements that wells can't be so far from, let's say, like a septic system?
The only time that you get into dealing with issues with wells would be distances to septic systems, and that's not an issue here. We don't regulate the location of wells, we don't have anything to do with well quality or water quality, and there's no setbacks from your impervious surface to an existing well.
Thank you. Anybody else? Any questions? Is there a motion? Well, we're gonna start with the criteria, A through F again. We'll have a motion and a second, and then discussion on each one of the criteria, and then have a vote on that motion. I would move that the need for a variance is due to the unique circumstances of the property and not to the general condition of the neighborhood. Is there a second?
Georgia Woodbury, I second that motion.
Discussion. I don't think that the property together, the whole lot, I don't think they're unique. I just think what we have is we have property side by side, and the question really doesn't go to the uniqueness of any of the properties, it goes to kind of a driveway with impervious surface that makes the impervious surface of the three lots, one, two, three, plus the house lot, which is immediately adjacent to it, has the potential of increasing the impervious surface by, what, 5%, Tammy? 4%, somewhat like that?
I don't know the exact figure, but it would be pretty minimal, considering that even if they have a 50 or 60 foot, I think it's a 60-foot right-of-way, that entire right-of-way would not be paved.
It says on the applicant now that Derek's pointed out, 6.2%.
Right, and so that would all depend if they do one house, that driveway doesn't have to be as wide as if you did two houses. So the width of the driveway increases with the tier of the number of houses it serves. So I think for one house, I think it's maybe 12 feet wide. Even though the easement's 60 feet, that doesn't mean the whole strip will be paved.
When the driveway was denied, Tammy, I guess, do we have that?
Right here.
It's in the exhibit, okay, at page
Yeah.
27-9.
Right.
Does it tell us how wide they asked for?
No, I think it just discusses a 60-foot wide easement right away.
Are you looking for the width that they
I'm looking for a
proposed on the
width,
driveway
yeah.
application?
I'm looking for a width, yeah.
That when Greg Rand and Bill Chapman applied for the driveway permit, you wanted to know how wide they proposed that to be, correct?
Exactly,
Yes.
which would result in the denial.
Correct. I don't know if that application was included in the packet.
It is. It's Exhibit 6, I believe, is the driveway entrance permit application, and the proposed width of the entrance was 18 feet.
Okay.
18 feet is the width of a standard road.
That's the entrance.
Right, the entrance typically would possibly be required to be a little bit wider. But even if you assume the entire driveway is 18 feet, that still doesn't mean that they're gonna pave or make the entire right-of-way impervious surface. So it's only gonna be whatever they need for that.
Do we know what the acceptable width of a town road is?
Again, it depends on how many houses it serves. So if you have one house, it may be 12 feet wide. If you have 5 houses, you could jump up to 20 feet.
We're applying for one house,
I'm looking at the future though, Mr. Nagel, also.
but if there's more development, it would have to come back here.
It would have to come back to the planning board, right?
I don't think you can fairly rule on what
Cor-
might happen.
Correct. It would have to come back for planning board approval if they did more than 2 houses back there, because that would trigger subdivision review.
Okay.
Usually, if you get into a 60-foot right-of-way, that's usually a road that serves that's like Lewiston Road. So I think that answers your question. Or does it? If you have a follow-up, go ahead, Brad.
It does. Mr. Nagel, where would the placement of the driveway be in this 60-foot right-of-way?
Right in the middle as shown on page 13. The permit you just look at doesn't show the easement. Well, it does show the easement. If you look on page 13, you'll see what's that, a 12-foot wide driveway?
That's shown as a 20-foot.
20-foot driveway, right in the middle, that's what they plan to build. Which is 1/3 of the easement. The 6% assumes a potentially 30-foot or 40-foot driveway in case commercial development would happen. But for the purpose of this application, it's 3%, because this is just a 20-foot driveway.
That means there's at least 20 feet between them and the property
And with all
line.
due respect, I thought we were talking about whether the site was unique or not.
Well, I think the board has the right to ask whatever questions it wants that would lead us to make a decision on whether we think it's unique or not.
Correct, and Mr. McCall just gave me some documentation that says that, pretty much a 30-foot wide driveway would be used for commercial activities. But just to give you sort of a spatial reference, say Lewiston Road or the road on Portland Road, those are probably 60-foot wide right-of-ways compared to, like, say, a private road that would be like Trestle Way. It's narrower, just so that you see the comparison.
I'd take a broad guess and say that the easement for Route 100 is only 44 feet. 22 feet either side of center line. But that being said, and of course, we're looking at 2025 when Route 100 down through that section is supposed to be widened anyway and improved. At least according to the DOT website soliciting comments for the 2.2 miles from Wayside Drive to Auburn.
You show a paved apron at the beginning.
Pardon?
You show a paved apron at the beginning of the drive. out on
And the
most of
paved apron is where the 18 feet or the 20 feet wide is, or is the entire driveway 20 feet? I don't see that on this.
I don't either.
Typical road sections on there.
If you look at the road section on that.
Yeah, I see that. So are we making a road or are we making a driveway?
That's a driveway, it's always been a driveway and never been anything other than a driveway. And it's a residential driveway, so the curb cut's on the right.
So there would be 20 feet from the edge of the driveway to the easement line, and how far from the easement line to the Sear building?
You have to look at page 13 again.
Still there.
I don't know that anyone has mentioned or measured that.
Well, I mean, the fact that a
Okay,
parking areas behind the Sear building.
Plan 5 again.
Which one the plan is?
Plan 3.
Plan 3.
Exhibit 2, page 3.
Three?
Yeah.
What section are we gonna find that dimension on?
There's no actual dimension written, but it gives you the spatial reference. It shows the Sear auction building and the right of way in the same plane.
Okay, where do you see that?
Mr., can I
Page
approach?
3, exhibit 2, page 3.
Exhibit 2, page 3. Thank you.
That's the distance that's not measured. I'm guessing it's 20 feet. Scott said it was 20.
There's parking out there behind you, is that correct, Scott?
Excuse me?
There's parking out behind the Sear building?
Yeah.
And how do they access the parking out behind the Sear building?
They come in the front between storage and my building, and they drive around the back, they drive around.
Immediately around the back?
It's tight on this end, it really
On,
can't go.
on the Lewiston end, it's tight? On the Lewiston Road end?
Yeah, very tight.
Okay. So the concern is, from your perspective, if the driveway, I guess I need a better view of the driveway.
Can I approach?
Yes, please.
The 11 by 17, the
11 by
gray
s-
lines was
this one?
basically just a blown-up version of this to make sure that all of you had this to reference, so I actually gave this to you.
Okay.
So if you take this,
Mr. Nagel, you wanna, are you gonna be okay looking at it? or-
Come up, take a look at what we're talking about here.
yeah, no, I'm just trying to give them reference,
Well,
so
it's still,
wherever this, so where is the,
The building doesn't show on that.
oh yeah, it's right
So
here.
pretty much,
Doesn't show on that.
right, but pretty much, see this chunk right here, and I'm looking at this, that is this corner.
Okay,
So his easement is down here someplace. I just wanna make sure that you understand how this correlates to that.
okay,
So
so,
that's the location of the
so
easement.
we'd be looking, where the easement's 60 feet, we'd be looking 20 feet from the property line, then road.
I think it's a 10-foot setback from the property for a
That
driveway.
other plan shows that more clearly that I just hit you.
15 feet.
The other plan that we can't see because it's so small?
No, not that
Yeah,
one.
keep-
This one.
Scott, Plan 5.
This is it, this is Plan 5.
Well,
Well, can I just finish making my point? What I'm trying to do is let the board know, just to give a spatial reference, because it's not drawn on here, of where this right-of-way goes through, and it basically cuts through right here. So, just so that all of you know where it's located on this plan,
that's correct.
okay?
So if you compare page 3.
Because I think it will help,
right,
because I think you have some, I think there's some confusion with regards to some of your questions, and
Exhibit 2 shows it very.
Exhibit 2.
Yeah.
Okay, Exhibit 2, let's find Exhibit 2.
Exhibit 2 is page 3.
No,
Okay, there it is.
first one. See, this is where I said it was 24 feet from that corner to there.
So 24 feet from that corner to the easement line, and then another 20 feet, so it's 44 feet from the building.
Correct.
Okay,
As long as they build it as they say they will.
yeah, 40, it'd be 44 feet from the building. And your concern is this corner up here.
No, well, yes, my well is right, no, my well is right here.
Okay.
And I'm
Is
concerned.
that, that little dot right there probably?
Yes, and so this is all wetlands in here, this is, I can show you pictures of this.
No, well, we're good.
Yeah, okay, but that's, right now you can just squeeze through here, so if they don't, if they build too close to this line, people are just gonna drive
So-
in.
Scott, people can drive in anyway through the
No,
front
no,
door.
this,
What's the big secret about driving in the back door?
Mr. Nagel, this is our time right now. When people drive around to the parking lot, do they drive around from the front of the building this way?
Yes, yes.
Is there any type of buffer at all in here? It's all woods. So you're concerned that people will turn in the driveway, stop their car and park and walk through the woods.
No, I was concerned that they're gonna build this, they're gonna cut the trees to build the driveway, right? They're gonna put impervious surface in.
Okay, this is all woods in here. That whole easement right now is
And we're only
woods.
gonna
Correct.
clear enough for a 20-foot driveway. There's gonna be no possible way to drive from the driveway onto Scott's land without hitting a tree. I'm sure he would agree with that.
Really, an onsite would be so helpful. It's so hard for me to explain it to you, but if you could see it.
No, I'm familiar with Trussell Drive and all through, down through there. I ride my bike down through that way, so,
Yeah.
okay. Is this the right one? Make sure this is the right one. I guess I just don't see as we continue to discuss what the unique circumstances are of that particular property that would prohibit a person putting a driveway and have a gravel driveway. I mean, if it was 20 feet wide, if it was 15 feet wide.
So why is it unique?
Exactly.
Like why?
Well, the road as proposed,
Folks, please.
the road, as I understand it, I'm just summarizing, so if I've got it wrong, I want someone to tell me. But the road as proposed in the application by Chapman and Rand is in the middle of the easement. A 60-foot wide easement, and it's a 20-foot wide road, so there's 20 feet from either side of the road to the boundary of each easement. Do I have that right so far?
If they do that.
That's where it's proposed in the plan that was submitted, and that's what the focus is here tonight. The edge of the easement toward the old Sear auction building, which you have as the Grove building, it's approximately 24 feet between those two things. So actually, there would wind up being 40 to 44 feet between the building and the road if it's built in the center of that easement. And that's what was shown on the plan. Are we all in agreement with that? I just want to try to summarize it, if that's important to the board. Okay.
Any other questions or discussion regarding this motion? Again, the motion is that the need for a variance is due to the unique circumstances of the property and not to the general condition of the neighborhood. There's been a second.
Would the board like to try to articulate a reason why? Maybe you started, but now that we've had all this discussion.
Well, I guess I'm still trying to figure out what the unique situation is.
Well, I think you heard Mr. Nagel say that the uniqueness was that it has an easement over adjoining property that can't be used because the adjoining property, if for whatever reason, it meets or exceeds its limit for impervious cover. And on the other party, I think was saying that that's nice, but that's not unique to the property. I don't mean to, is that approximately right?
And I think the other point is that the previous easement to the property no longer exists. So this is the only access to the applicant's property.
No, Trussell Way is.
Except for
Well,
Trussell.
Trussell Way is an access, and to note,
have to
contemplates a
rebuild it.
substitution possibly in the future if it was built to town standards.
But they're not gonna build this to town standards, if it was.
They'll have to at least meet whatever standards exist for a driveway.
And there was something to do with 1,600 feet.
That goes toward the feasibility.
It's also unique, I mean, in terms of having to build a 1,600-foot driveway as opposed to a,
It's only a $300,000 house, but it's $100,
$1
$1 million property at that point.
Yeah, they'd have to increase the road and.
okay. Are we ready to vote? All those in favor that the need for the variance is due to the unique circumstances of the property and not to the general condition of the neighborhood?
I still don't understand.
Well, I guess the unique, the unique part is, I think about, is that other than going through Trestle Way, which would require an extremely long driveway,
Okay,
a huge amount of money to do forestry work, land prep, perhaps even vernal pool work, depending on, the DEP line. I think the property's in kind of a unique spot that access is not easily accessible. And given that fact, somehow or another, the applicant received a easement of 60 feet wide to be able to access their property. And that's the unique circumstance here, and the applicant wants to make use of that easement. Although we would be looking at granting a 6.2% increase in impervious surface, but that's over the entire lots 2 and 3.
No, it's just on 3.
Just on 3? Okay, on lot 3. So there's a huge amount of pavement and gravel surface there anyway, so we're looking at a 6.2% increase on that, and
Maybe up to 6.2% depending upon how wide they make that, but, right.
all those in favor of the motion? All those opposed to the motion? We need more time.
I think we should just skip that one and go to B for now.
Okay, we'll do that.
I think it'd be easy.
Do we want to just formally withdraw that motion for now?
I withdraw motion
And the second?
for letter A, and we withdraw the second. Somebody withdraw, who made the second?
I did.
Would you withdraw the
was-
second?
I withdraw my second to the
Okay.
motion.
Moving on to letter B. I would make the motion that the granting of a variance will not produce an undesirable change in the characteristics of the neighborhood and will not unreasonably detrimentally affect the use or market value of abutting properties. Is there a second?
Georgia Woodbury, I'll second the motion.
Discussion.
I mean, he's not really involved. It's
No,
the
that's,
other
he's not
half.
involved in that at all.
Yeah.
I'm still not sure how putting this driveway through will affect the market value of the property that includes the Marrona Grow operation. How it will affect the product that's produced in terms of marketability or sales, especially if the well water's not being tested. Is the well water being tested now?
Yes. And I've got a $20,000 special system.
Okay,
But salt is the biggest deal, salt.
so that's actually Route 100, right?
Yeah, will that be closer, this will be closer than Route 100. And it's
But
just, it's not that, it's also people who complain about smell. I mean, I can see it's gonna be a nightmare, the neighbors are gonna complain. The only reason the neighbor doesn't complain across the street is he grows marijuana.
Don't wanna know. But currently, you have the property, you have the required filtering systems and place for smell.
Yeah,
and-
it's a double wall building, it really doesn't smell except you open the door. But, yeah, that's why we put the language in the easement. 'Cause I can see something like this is gonna come down the road.
Could I speak to the salt issue? Between the right-of-way and where we enter that property, the stream that we spoke of runs between his building and where we'll enter our property. Seems as though if there's the salt issue, the stream would take it, send it across the street. It would never make it to his well, which is out behind his building.
But you salt a driveway?
Some people salt their driveways and some people don't.
Yeah, I guess, okay. But a gravel driveway. Oh.
And if you ever sold a building, the neighbors by deed would know that there's a driveway there. I'm not a real estate broker, but I don't see the value of property, commercial or residential, going down. I don't see a negative impact on the value of the property itself. Are we ready to vote on letter B?
Yeah, the only thing when I'm reading this, that is just keeps coming up in my head, because we keep on reading or market value, but I'm also reading not producing an undesirable change to the characteristics of the neighborhood. And I think if I'm hearing correctly, I think that's also a concern of Mr. Liberty, because he was talking about removing the trees, the salamander eggs.
Those are
etc.
in a different part of the property.
Oh, that's a different one, sorry.
Different part of the property, it's down back.
And very honestly, a major stretch of that road is residential.
Yeah.
I mean, there's the housing development, the condominium developments above Trestle Way, or right near Trestle Way and beyond the Grove, it's all housing, and across the street, it's housing, and I don't know that it has a detrimental impact on the neighborhood. I mean, you probably won't be able to see the house from the road anyway. Right.
Does the easement distance from the building factor in there at all? You discussed it earlier.
Well, I think that's one of the unique,
Okay.
No, that was in the unique part.
And we've offered to move that easement, so they don't even have to cross the brook. So then they have no brook issue at all, and it was their recommendation.
so in other words, if you move the easement 40 feet, right to the edge of the property,
Yep.
would that make it more difficult on the applicant?
I thought the public hearing closed. He just offered up a comment unsolicited, not in response to your question. And if that's the rules we're playing by, then I think both sides were given that opportunity.
We're here to resolve a problem, Mr. Nagel, not create more. I mean, if this issue can be resolved to the satisfaction of the applicant by moving the driveway 20 feet towards Trestle Way,
No, the other way,
I mean, towards Route 100.
the other way.
well, Trestle Way's up here.
I thought it was over here.
No, Trestle Way Trestle Way's above, towards Cole Farms, right? Yeah, that's what I
Oh,
thought.
okay,
Trestle Way's up here.
okay,
So his question was, they've offered to move the right-of-way.
that way, okay.
Jeez.
Some of them are right side up, some are upside down, so.
Any comment from the applicant,
Yes. My client,
specific to the offer to move the right-of-way? Please.
I can't speak to offers that might have been made in the past. I can tell you that no offers have been accepted.
Okay, I understand
And I
that.
can also point out that if you go back to page 13, again, where is it?
On page 13.
13. Of the exhibit. If you push the driveway to the top of the page towards Cole Farms, it's going to run into that highway culvert and interfere with the drainage of that highway culvert. And I'm not sure that's a good idea. The driveway's gonna be 44 feet away from his building. And there are trees in between.
May I ask a question?
Sure.
Can you elaborate more when you say not a good idea?
I'll just explain that I'm not aware of an offer to move the driveway over there. And because of the road culvert, the engineers decided that that's where the driveway should go. It was Mr. Liberty who chose the location of the 60-foot easement and put it on his plan and offered it to my client. Now he's saying he doesn't like where the easement is and is asking you to have us move it. Well, unfortunately, the world, you don't get to change easements that you were given 2 years ago.
Good point. Thank you.
You will.
I am ready to vote on this particular issue.
Okay.
Because I don't think the request to use the existing easement will produce an undesirable change in the character of the neighborhood. It's mostly forested, it's mostly residential, and I don't think it's gonna affect the market value of the property and the physical property or the abutting properties. All those in favor of letter B is unanimous. Letter C, the practical difficulty is not the result of action taken by the petitioner or a prior owner. Is there a motion? I make that motion. Is there a second? At least we can get discussion going.
I second that.
Anthony seconds. I don't think it's the petitioner's fault that the easement was placed where it was. The landowner, somewhere down the road, offered and established the easement that was recorded at the Cumberland County Registry of Deeds
And accepted.
and accepted. So I don't think that the current owner of the property seeking the easement or any prior owner of the property where the easement leads to had any role in that or could be faulted for requesting that the easement be honored. Any other comments? Any questions? Are we ready to vote? All those in favor that the practical difficulty is not the result of the action taken by the petitioner or a prior owner? It's unanimous. I would move that no other feasible alternative to a variance is available to the petitioner. Is there a second?
Georgia Woodbury, I second the motion.
Does anybody, at least here, think that there's a viable alternative that,
What are the two options? You get
well,
extended.
to leave it the way it is,
Or trestle way.
or find another way to the property, like via Trestle Way, that it was implied that there was, what, a 1,600-foot?
Yeah, it's all right here, written in the,
It's written here, yeah.
right here.
on page 10 of 11. And that's in the memo section, right?
It's in the very front section, yes.
Okay.
It's approximately 1,600 feet from the new residence to Trestle Way. Plus, they would have to upgrade 400 feet of Trestle Way to town road standards.
Yeah, what,
The cost of that would probably exceed the cost of the residence.
you know, on page 8, it starts, Trussellway, upgrade the first 400 feet of Trussellway to town road standards and build another 1,200 feet of new roadway to town standards to get to the single-family residence. That's 1,600 feet.
Mr. Chair,
Yes.
may I just briefly comment on Mr. Nichols' statement?
Well, it's not a statement, it's in his submission.
No, it's just his comment, again, I just direct the board's attention to Exhibit 1, which shows the layout of the lot, and
Got it.
there's no suggestion we couldn't build closer to Trestle Way. Thank you, Mr. Chair.
Certainly possible. But then again, we go to the term feasible. And what is feasible to, you know, the common person? Is it really feasible that we spend $1,000 a foot for gravel over 1,600 feet and end up spending $160,000 for a driveway? Or do we grant the petitioners access to the current easement to build a 20-foot driveway?
Even if my clients built a house near Trestle Way,
We're not gonna argue back and forth. That's my thought. And this is our discussion time, and I think I've been more than generous asking, allowing too much back and forth. Are there any other comments or concerns about letter D?
Derek Shirley, I think too, there's no other feasible alternative. So that, like we said, we were told wasn't Webster's dictionary, but we were told the definition of feasible, and I kind of look at it as, like was said, feasible doesn't always mean cheapest. So that's kind of where I'm chewing on. It's like pretty adamant, no other feasible way, meaning how I read it personally, no other feasible, not like, or think opposite, if everything was perfect, what would be a feasible thing we would accept if this is not feasible? Do you know what I'm saying?
I do.
Okay. Sometimes I talk weird, so
Oh,
I just want to make sure.
I've learned that, though.
Yeah.
Are we ready to vote on this
Yes,
letter?
I am.
All those in favor that no other feasible alternative to a variance is available to the petitioner? All those opposed? The vote is 3-1 and carries. I move that the granting of a variance will not unreasonably adversely affect the natural environment. Is there a second?
I second that.
Nobody seems, I don't think that,
They're gonna have to take some trees down, but not that.
we're gonna have to take 20 feet of trees down, 20
Yeah.
feet wide. And I'm not sure, that that's gonna affect the natural environment. It doesn't seem to be that anything else is in danger in terms of nature.
I
And I
wouldn't think
think
about it from a tree standpoint, I would think about it from that wetlands and stream standpoint.
Well, they've already been to the
They've only been to
DEP.
DEP.
Right.
They've looked at it,
and they've said it's okay to do what they were doing. They've got the drawings in there.
I mean, very honestly, a lot of other things that the board has done in the past, DEP has taken a very harsh look at, and
Mhm.
sometimes they haven't commented at all. And if there was a concern about vernal pools, I would hope that DEP at least looked at the plans and maybe even looked at the site. But again, we don't control what DEP does or how they do it. But the presentation's material says they're not opposed to putting the driveway road in that spot. And they certainly wouldn't have, if they had said no, then that would have been the end of the argument right from day one. All those in favor of the motion that the granting of the variance will not unreasonably adversely affect the natural environment? It's unanimous. I make the motion that the property is not located in whole or in part within the shoreland areas as described in Title 38, Section 435. That's correct, is it not, Tammy?
Correct.
Georgia Woodbury, I second the motion.
Well, we know by the zoning maps that it's not in a wetland, a protected wetland. And that conversation certainly has come up before in other cases, and DEP has ruled one way or the other. And again, they've determined that there's no wetland there. Any other comments? Are we ready to vote?
Mhm.
All those in favor or agreement that the property is not located in whole or in part within shoreland areas as described in Title 38, Section 435. All those in favor? It's unanimous. This brings us back to a letter A. That the need for a variance is due to the unique circumstances of the property and not to the general condition of the neighborhood. I make that motion. Is there a second? At least for discussion.
I'll second.
Derek seconds. Again, I have to admit, I'm struggling with this one.
The general condition of the neighborhood is majority residential with some commercial in the neighborhood overall, not this one lot. If you look at that one lot, then
Jim, can you offer any guidance on this?
I mean, the need for the variance is because of the lot coverage, the impervious coverage on the abutting lot, which is not a neighborhood condition, but it's something that has developed because of the use of that property, the development of that property by the abutting owner. So it's not a neighborhood condition. This is a unique circumstance in several ways. Usually people are seeking variances for their own property, and this is not the common one. And so as far as this property's unique attributes, it's that there's a great cost of developing access over the approved access. Perhaps and that's something that isn't also copied throughout the neighborhood. It's this lot, this parcel, the way the subdivision's laid out, which,
I guess thinking about it now, it also seems to be unique because the three parcels kind of split accessibility to the home, the site of the home, in such a way that, I mean, the impervious coverage in a large part limit was caused as a result of the improvement of the parking lots, if you will, access to the Sear auction building. And be it by need for them to have a larger parking lot, gravel parking lot, or more easy accessibility to the storage units which they've sold off. It seems like there's a couple of contributing factors to why we have this now unique situation of, geez, I can't build my driveway on the easement that I was given because the other folks put down more gravel than they probably should have, but which was allowable by ordinance. Is that correct, Tammy?
Excuse me, what was the question?
I guess the question is, when the auction house storage area submitted their plan, is there an allotment to be able to increase the impervious coverage without coming back to the planning board, or?
No, basically, originally, it was Gray Holdings did a 3-lot subdivision.
Okay,
Held under all of the same ownership. They submitted a plan to the planning board that showed a proposed like 52 or 55%, something like that.
okay,
And the maximum allowable, I think, is 65. I don't know the number specifically off the top of my head. And so when that was all one parcel, you look at the impervious surface for the entire parcel. And so it's 65% over that entire parcel, which, if I may, I'm sure that you guys have driven by, but if you take this lot, so this lot has now become a residential lot.
correct.
This lot is mainly,
The lot
is
in the
where
middle
the
where
storage buildings are,
Yeah.
okay, that's really developed. So there's gonna be a greater percentage of that percentage of impervious surface is gonna be located where these storage buildings are.
Okay, so you're pointing to lot 2 on the DM Roma plan that was issued earlier this evening?
Correct.
Okay, and lot 1 is the residential?
Right, and just so that the board knows, and so initially, whatever proposal was that was brought in front of the planning board for the lot coverage was for that entire large parcel. So it was, if it was 52% of it was really proposed kind of on that side, where the storage buildings are and where the existing auction building is.
Okay,
Okay?
thank you. It appears to me that with the increase of structured infrastructure, in short, the storage buildings, and the need to have the storage buildings accessible to their customers, that there was a greater need to increase the impervious surface for accessibility and ease of accessibility to that lot. And now that lot has been removed from the picture, but still lies within the whole scope of Tammy, with those storage buildings now being sold, and Scott, that piece of property been deeded to somebody else? So
Correct,
now-
it's my understanding that the storage, the 3-lot parcel the 3-lot subdivision that you have the plan in front of you, the one, say, furthest to the left-hand side, which would be the residential,
Yeah,
has been sold.
that's a separate lot with a separate deed.
Separate lots,
Okay.
correct, Scott? Okay, separate lot, separate deed. There's a new house there right now that's
I
been
gotcha.
built for sale.
Is
The
lot
center
2
lot is the storage buildings. That lot has also been sold,
Is that now a separate lot with separate deed?
correct.
Okay, so does the current impervious surface of lot 3,
Which is the Sierra auction building, correct?
correct?
Okay, yeah,
It doesn't look like that exceeds 55% of that lot coverage.
correct.
No, it's 70% on lot 3.
Really?
Yeah. The engineer broke it down in the letter to you guys.
There is a letter in here, I saw it. I don't know what it is, but I did see it.
That is, let me find that one again. That doesn't look like 70%, does it?
I saw it
Is that
somewhere.
letter that you just referred to, the July 25, 2023 letter that you gave us this evening?
Also submitted by the applicant as exhibit number 10.
Thank you. That makes it
That
easier.
helps.
Thank you.
Yeah, now that I have the plan in front of me, I don't know what the percentage of that coverage would be on lot 3. And I don't have those numbers in front of me.
Each lot was calculated separately. They weren't cubed. Each lot had its own impervious surface.
In the original submission
If you look at the plan that was approved, it tells
for
you.
the planning board?
Yes.
Okay.
It tells you each
Okay.
impervious surface of each lot.
I wonder if we have that.
This one right
Oh, yeah,
here.
that makes
Oh,
No, the plan, the original.
No, I don't know.
Mr. Nagel, in your submission, do we have the original plan? I think you said we did. For,
Which plan, sir?
Subdivision
for
plan?
the subdivision plan.
Liberty subdivision?
Tab 5, page 9?
Yes.
Okay. That doesn't tell me acreage though, does it, or coverage?
No. But you can't read it. Yeah.
Well,
Sir, I think I wanna, while you've asked me a question, this does show where it will be. And I wanna clarify that the ordinance standard doesn't say the lot needs to be unique. It says the circumstances of the lot
Okay.
needs to be unique.
We got that, but the lot is part of the uniqueness. And and where it is contributes to any finding of uniqueness or not.
Okay,
We
well, I
look,
agree
we
with
look,
that.
we look at the whole picture, not just, a building and some gravel.
Mr. Chair, just to help, if you take a look at exhibit 5, you'll see that there's very small writing under it.
Yes, there is.
Lot area and impervious surface for each separate lot. Lot 1 has numbers, lot 2 has numbers, lot 3 has numbers.
Yeah, but you can't,
We have magnifiers.
yeah, you can't read it.
Oops, there I go, banging the microphone
Do
again,
you
I'm sorry.
need a magnifying glass?
50.7% is what lot 3 says.
What's
Lot
it say?
3 now is 57.3%?
50.50.7%
Wow.
was impervious surface for lot 3 on the plan that was approved by the planning.
Just out of curiosity, where do you see that?
Right here. This tiny, right here.
Wow.
Yep.
Wow,
And has that ever been amended?
Not to my knowledge, no.
that says proposed impervious. I can't
Yeah,
see it
so
now.
We don't know how much impervious surface is there today. The code operates is more than 5,000 square feet.
Do we actually know, Tammy, how much impervious surface is on lot 3?
If the letter from the engineering firm that they sent to us, they basically said that it exceeded 65%.
Well,
And the estimate is 65 to 70 if that's specific to lot 3.
the letter from DM Roma that was offered this evening and that appears on tab 10 says, the conclusion, the last sentence is at page 29, exhibit 10.
Mm-hmm.
Additionally, the additional driveway, meaning this proposed driveway, would likely cause lot 3 of the recorded subdivision plan to be in nonconformance with the Town of Gray zoning ordinance section 402.5.4 district's dimensional requirements by exceeding the 65% maximum impervious surface allowed in the commercial zoning district. So this doesn't tell us what it was at. It just says that this driveway would make it go over 65%. That's the way I read it.
And if the developer had built it to the 50% the planning board approved, then the 6% my client wants to add wouldn't even come close to being a problem. Fundamental problem.
Okay, that's good.
Liberty has overdeveloped his site. And that's one of the things that make this unique.
Mr. Chair, with all due respect, I did. Rodney Boynton had owned the property for
Scott, I know that, and I'm gonna enter this up as comment. The Sierra Auction House was existing before the storage facility was ever there.
Yes.
And the Sierra Auction House property probably is, at this point in time, an unsuspecting contributor to the expanse of the impervious surface, not because of the Sierra Auction property, but when everything was added up together and we added storage over here, I'm saying this out loud, then we had an increase of impervious property well beyond what the original Sierra Auction House had. I drove by that almost every day and saw oil truck on there, spilling oil all over the place. So it's not that it was there. So I think the fact that that just adds to the uniqueness of the problem is that the expanse of the storage facility, which has now been sold, said at the time of the permit is, hey, listen, this property in fact is unique because it's been subdivided 3 times, and when parcel 2 was developed, the impervious surface went well beyond what the original property had. So I guess I would have to say that the property truly is unique because of the development that's been on it probably since the code was written. And that's certainly out of control of the people that are asking to build a driveway. I mean, it's not really good for anybody, but that certainly is a unique contribution to that. I mean, that's my thought. I'll see if I can find all the other stuff I have. Okay, I admit, I've gotten lost over here. Okay, let's put that there. That there. That can go up there. That, I believe, can go up there. That can go there. Okay, where's the thing I was writing on there? Right there, I think. Nope, that's the last one. Bear with me, folks, I've lost somewhere on this desk what I was working with. Kind of looks like my desk at home. I kid you not. Now, that is it. So the motion before us is the need for a variance is due to the unique circumstances of the property and not to the general condition of the neighborhood. Is there any more discussion or thoughts on that? All those in favor or favoring the need for the variance is due to the unique circumstances of the property and not to the general conditions of the neighborhood? It's unanimous.
Mr. Chair, could I raise one brief point of order before?
Are you sure you want to do that?
I do.
Is it hurting your case?
Well, I don't have a case at all.
Well, it is.
Ben.
I don't have a case at all. My one request, before you take a final vote, and perhaps your attorney who's been through this many, many times will do this as part of your written findings. My only request is, there seems to have been debate amongst the parties about the scope of the easement that was granted to the appellants and whether that allows them to create the impervious surface that they're seeking to create by way of this variance. Attorney Nagel was involved in a case a couple of years ago in the town of Casco that just raised the issue, the law court at least raised this issue, of determining whether or not the applicant has right title and interest to seek what they're seeking. So I don't have a particular position on this one way or the other. I just want to make sure that that point is clarified in your findings to make sure that there's no need for a remand if there is an appeal.
And to elaborate on that, when you require someone who comes in for a permit to have right title or interest, show me you have a deed, show me you have an option agreement, show me you have an easement, show me you have something that gives you some connection to the property, so that this isn't just an abstract exercise. You really have a property right you can use. Normally, the courts have said to planning boards and boards of appeals, if someone comes in with a deed, with an easement, you don't look beyond it, you don't wear black robes, you don't interpret that deed. The Casco case said that basically you have to look at it enough to satisfy yourselves that they can actually do with the property what they're seeking to do with that permit. So they're not just looking for a driveway permit, they want to improve the driveway 20 feet wide. And so what's suggested is, could you determine that this easement gives them the right to do that? That's subject to a court saying otherwise. But
Do we have some order back?
Yeah, I can't hear.
Mr. Nagel, we can hear you.
I mean, you don't wear the black robe, so you don't get to make a final determination of legal rights as among parties. The question is the easement sufficient to at least allow the person, Mr. Chapman, Mr. Rand, to do what they're seeking to do, which is to build and improve a driveway?
Well, the easement exists. What they're asking for is a variance to increase the impervious surface.
Right, and so I guess the question is, do you read the easement, which, as I read, is for a perpetual right and easement for passage of pedestrian and vehicular traffic? Is that sufficient in this board's mind to give them the right to improve that easement, knowing that that's, ultimately a court decision, but?
Ultimately, I would say yes, because there's nothing there now. So what they're trying to do is gain access over the easement.
And you need to improve it in order to have the
Exactly.
vehicular access.
To
Is
have
that how you're-
vehicles access, yes.
Okay, so an easement for vehicular access necessarily, in the board's mind, means the right to improve it for vehicular access.
Well, there's nothing there now, so I guess I'm supporting the fact that we're granting an easement or approving their request for a variance so that they can in fact access the property by way of the easement.
Mm-hmm, okay.
Which means that obviously they would have to improve the land to make that possible.
Do we want to put that in the form of a motion, just so that way it's on the record?
I will try to do that
I understand, and I'll
in my
try to
main
help.
motion. Okay, I've got to find everything now.
That would be at page 5, the easement deed from Grayland Holdings LLC to William Chapman and Gregory Rand,
On page 5?
page 5.
Oh, page 5.
Yeah, page 5. And that's on that,
Way before here.
about halfway
Page
down that
5 in
first
the
paragraph.
memos.
No, actually, I'm sorry, it's under 3, page 5.
Section 3, page 5.
Yes, sorry.
Okay. Too much information.
Well, we found it.
Where's my agenda? Right there. I would make a motion that the variance requested the practical difficulty variance requested by William Chapman and Greg Rand for additional lot coverage on property 2 Storage Way, comma, Gray Tax Map 028, 026, 002, 000. Said property located in the commercial zoning district and owned by Grayland Holdings LLC be approved. And such approval is to allow access over an existing easement to their property for the purposes of building a residential home. And I'm looking at you, Jim.
Should we add
With
that it's to be 20 inches?
such access under the easement from Grayland Holdings to applicants, necessarily implying the right to improve the driveway as shown in the permit application.
Okay, folks, we're gonna take a minute and a recess while we
Get our
develop a
words.
draft motion that properly addresses the motion to approve. And let's take 5 minutes to do that.
Should we specify it's a 20?
I'm gonna Everybody come in.
And now the people gets to do the final exam. Okay, the concluding motion would be this, and please feel free to jump in if I've got it wrong. The ZBA.
That's us and not you folks.
That's right. The ZBA hereby approves the practical difficulty variance application of William Chapman and Greg Rand for up to 6.2% of additional impervious coverage on property at 2 Storage Way, grade tax map 028-026-002-000, the subject property, with applicant's proposed 20-foot wide driveway to be constructed in the center of the 60-foot easement over the subject property as shown on the plan entitled Plan and Profile of Proposed Entrance off Lewiston Road, Gray, Maine, for Bill Chapman and Greg Rand, dated October 2023, the plan, with a condition of approval that the applicant maintain a wooded buffer of existing trees along within 15 feet of the northern bound of the easement shown on the plan. And with the north edge of the driveway in said easement to be 20 feet from the north bound of the easement. That should place it in the center. Semicolon, the ZBA interprets the easement deed from Grayland Holdings LLC to applicants as granting the perpetual right and easement for passage of pedestrians and vehicular traffic to necessarily include the ability of applicants to improve the easement to allow for use of the easement for those purposes. You want me to read it back again?
No, I understood every bit of that.
Okay, is that where the board wanted to go?
I believe so.
I
We
think-
wanted to ensure a buffer of at least 15 feet between,
You're
the
right,
natural
wooded
buffer, the existing wooded buffer to stay there. And the only other concern that we have maybe of the applicant, Mr. Nagel, is we want to make sure that the entrance to the driveway is clearly marked as private way.
Make it a condition of approval.
There we go.
With the entrance to the driveway being clearly marked private way. Add that to the motion,
Yes.
okay?
Could you just in simple English explain where the 15-foot buffer is?
Sure. So we all know, let's take, Mr. Nagel had the, let me see, I was looking at exhibit, if you look at page 13, there's a drawing, and that's the drawing for Chapman and Rand, showing the Lewiston Road and showing the driveway. It depicts the driveway as being right in the middle of the easement. And so if I'm looking at it so that Lewiston Road is at the top, then what we're saying is to the right, to the north, along that easement line.
On the Sear auction building side of the easement, we
Right.
want to make sure there's a 15-foot minimum wooded buffer maintained there.
Thank you, now I understand what you meant.
Okay. So if you're going 20 feet from that line, then, then the next 15 will be, you keep the trees there, the existing trees there.
Well, the 20-foot roadway usually has a shoulder.
Right, so you got your 5 feet and you.
Yeah, and there's 5 feet of shoulder and 15 feet of.
Well, it's would be 5 feet of unimproved, just grass or something growing there. We don't want,
Nothing will change in that difference.
we don't want that 20 feet to suddenly become 25 feet because, we're gonna have a sand shoulder. What you've got is 20 feet of roadway, improved roadway, and then we were gonna say 20 feet of buffer, but we know that you can't build a roadway necessarily over a stump or a root. So that gives you a couple of extra feet to make sure that you get the 20-foot wide, but a minimum of 15 feet of wooded buffer. That's the existing wooded buffer. We don't go in there and cut down more trees than you have to and try to assure the holding company some privacy.
And that will prevent the hoodlums from driving on.
Well, we don't know that, but that's why we also want that private drive to be clearly marked as private drive.
Thank you, appreciate it.
That being said, is there a second to the motion?
I second.
Shirley seconds. Any discussion on the motion? Seeing no discussion, all those in favor of the motion? It's unanimous.
Now, the board has to issue a decision, written decision with findings of fact and conclusions of law, and within 7 days.
You're gonna be busy.
On the 7th day, I'll rest. But if you could arrange for a brief meeting to adopt findings of fact and conclusions of law 1 week from tonight, if that makes sense. I don't know who I have to talk to about arranging space in the building or whatever. Tammy, would that be possible?
Jim, if it helps the town, I don't know the source of the 7-day rule.
State law. 7-day notice of decision under boards of appeals.
In other words, we have to issue to you.
Come on.
No,
the
that's,
se-
no,
no
I
later
gotta
than-
do what I
Something
gotta
in the
do.
ordinance, we will waive it. If it's
So
state law,
let me-
I'll be quiet.
So what is it that you need from me, Jim?
Can we meet here, or I can just prepare a written decision. I would send a courtesy copy to council. That doesn't mean it's open season to rewrite the decision, but a courtesy copy. The board would get it, take a look, and the board could decide, do they want to adopt it with changes, whatever. They would meet next Wednesday. It could be as brief as 15 minutes if they don't have any changes. It could be half an hour if they do. I don't know that we all have to come back here, but we could.
Does this need to be a public meeting?
It would have to be advertised. Well, everyone who knows about this meeting and has a concern is here. So we would list it, the clerk's office tomorrow, that there's gonna be a special meeting of the Board of Appeals.
Does it need to be noticed in the paper?
No, you wouldn't have time to do that anyway.
Correct, so just advertise.
Advertise as you would, like put it on the website, put it up in the town hall. Everyone who's here tonight knows, and it could be 7 o'clock if you wanna do it then.
Well, we have to find a space, I think the first Wednesday of, I'm not sure if it's this month.
Yeah,
that
if you
the
can
school
give me a
board
second,
meets at
Yes.
6:30.
I can go check.
Figure out what space.
Yeah, I need to
Just
go
consult
look at a
them.
calendar.
Thank you, sorry.
On a related,
Can we access the Town of Gray website?
procedure, we had a separate application for a administrative appeal, and we would like to table that, not have you pursue it tonight,
Thank you.
hopefully ever. And we will, the if obviously is whether or not Mr. Liberty and his counsel decide to file an appeal, which could
Okay, where do you
jeopardize
wanna go?
And if that happens.
Do we have a
we'll
meetings calendar?
Consider what to do with that other appeal.
Should be.
Given the hour, I don't know that the board wants to entertain another application
Well,
anyway.
very honestly, it's my opinion that where the variance has been granted to make the improvement, that in essence overrules the finding of non-compliance or the original decision of the code enforcement officer to deny the driveway. We have now approved a driveway as a result of the practical difficulty variance, and Ben might be able to chime in on this, so I almost think that the appeal can be withdrawn.
Well, I would agree with you, except for the fact there is a possibility that Mr. Liberty could appeal, and there's a possibility that Mr. Liberty could win that appeal.
That's true, but everything's really gonna be based on the granting of the variance.
You're correct, and if that were to happen, we would reconsider our options, which might include pushing that other appeal, probably not. So
I'll make a
let's
mo-
just
I'll make a
table it,
motion to
keep it
table.
simple, we'd just like to table it.
Okay. Motion to table
I can't find-
indefinitely.
Oh, here we go.
I make a motion to table the administrative appeal. I don't wanna say until a time certain, because we don't know.
Next Next Wednesday's the 6th, correct?
Right.
Yes.
There's nothing on the municipal meeting calendar. They get the town council executive on the 5th, Gray Town Council on the 5th, and then open space on the 13th.
Yeah, the school board sometimes
Thank you,
isn't
George.
listed as a municipal meeting, though. That's the
So,
problem.
would you wanna do this at 7 o'clock that evening?
Does the school board meet on that night, or we don't need this chamber for what we have to do? Because I
Doesn't
know the
need to be a
school board
public
meets the
meeting, though.
first Wednesday
It
of the
will be
month.
public in the sense of, yeah, we'll need to be able to tell the public on the notice that'll be posted in the clerk's office, and
Other meetings.
so we need to know where it will be.
School board.
I'm gonna tell you that December 6th, I'm gonna be in Knox County, but you don't need me for this. You know, you'll look at this and determine whether it reflects what you decided.
They don't have a lot on there.
We only have
Well,
October.
is the board all available at December 6th?
When I get back from Arizona,
Because I could find, what we could do is we could set the meeting, Brad, for a week from tonight. We don't have to do it at 7, we could do it at 6, if people don't want to be out as late, although it won't take
What
that.
works for you guys?
Whatever, flexible, yeah.
Let's do 6 o'clock next Wednesday.
And then we're gonna have to find the space to make sure this is not used.
We could always go upstairs.
Okay, fair enough.
I mean, I don't think there's gonna be anything upstairs, so.
No, that's good, that's a good point.
So it
And
will be
there's an
here
elevator
or
for-
So
upstairs.
here, December 6th at 6 o'clock.
And if it isn't in this room, it will be upstairs, and we'll just,
We're gonna say
just
town
put
hall.
a note right here
Yep.
telling people where. And I'll prepare a draft and get that to you for your review.
There we go.
6 o'clock.
6 o'clock,
Next Wednesday.
and it will be either here or upstairs, but they will, in
We're
this.
saying in this
yeah.
building.
I'm not sure if the school board meeting is here or in New Gloucester, because it meets here every other month. We certainly don't want to be in conflict with the great educators of our society.
Right, and so Jim, what we need to do,
Did you just
this is
laugh?
more of a procedural issue. Do we need to do minutes for that meeting?
It'll still be a regular, it'll be a special meeting of the board. of
Okay, so a
Appeals.
special meeting of the board, so it's a regular ZBA meeting, special meeting of the board just for this
Correct.
one item of business,
That's
okay? Thank you.
Thank you.
Is there any other business before the zoning board of appeals?
yeah, you're gonna table
Oh,
that.
this is
Okay.
true.
All right.
I make a motion that we table the administrative appeal of Rand and Chapman
Indefinitely.
indefinitely. Is there a second?
I'll second the motion, George
All those in,
Woodbury.
all those in favor? I make the motion that we adjourn this meeting until the first Wednesday, December 6th, 2023, at 6 o'clock PM
In this building.
in this building. Is there a second?
A second.
All those in favor? Folks, we are literally in recess until December 6th at 6 o'clock PM in this building.
I want to thank you for being so thorough, and I want to apologize for the way I'm wired.
We, you know, Mr. Nagel, actually, my expertise is I work for the prison